We're getting there. We've got about 44 people that have joined so far, and I think there's about 20 more. So hopefully they'll be here pretty quick. Okay, we're going to get started in just a minute.
Hello. What? No.
Okay, we're going to get started now. I'm going to start off by asking that everybody make sure that you're muted.
Hold on just a second.
I can see a few of you are not muted right now. Of course, if you're going to speak during the webinar, that's fine. You know, you have to unmute yourself, but for now, make sure that you're all muted.
How do I get out of this meeting?
Okay. All right. Okay, well, welcome to the, what's the date today? The January 28th, 2023 AAIP webinar. It's our first webinar of the season. We have 4 webinars planned today, or actually 3 webinars planned this year, and then at least 1 in-person session. So our next one, which will definitely be a webinar, will be on February 25th. And then March 25th and April 29th, we're thinking those may be in person at the Sheraton where we usually have these, you know, further information to follow. But welcome to the webinar. We've got a great slate of topics scheduled for today, and they will be in the following order. We're going to start off with basics of deed preparation, which is a presentation I'm going to lead, followed up by a presentation on the ins and outs of real estate litigation, which is going to be presented by attorney Brian Locker. After that, we have a 2-hour, the first 2 are 1-hour segments. The following one is going to be a 2-hour segment on a family law update. So Kelly DiCarlo, who is a certified legal document bearer, is going to talk about terminations, updates in family court rules and statutes, including talking about terminations of legal separations, the summary consent decree process, changes to Rule 14, information on the proposal for spousal maintenance guidelines, and much, much more. And then Alan Merrill will conclude the webinar with 1 hour on CLDP ethics, and that will conclude our program when we get to that. So, anyways, you know, hopefully it'll be. I'm sure it will be a informative and worthwhile class. So, couple housekeeping things I just want to reassert or talk about briefly. Let's see, participation. As you're probably aware, if you've used Microsoft Teams before, you can participate if you want to say something, contribute, which you're welcome to do, which I encourage you all to do. There's a feature, an icon where you can raise your hand, and I will try to look out for that best that I can. Of course, in the first segment that I'm presenting at, I might not notice as quickly, but I will do my best to notice if you've got your hand up. Also, if you you can just use the chat feature to make comments or ask questions. Again, especially during the first segment where I'm presenting, I'll do my best I can to notice what's going on with those. It's certainly at worst case scenario at the end of my presentation, I'll look through those and see if there's any questions that that were not answered. Let's see. Okay, verifying attendance. As many of you may be aware, if you've attended these webinars before, we use the magic word verification process. So what that means is that I have 3 just kind of random words that throughout the morning when we're having this during the webinar, I will give you a fair warning. I'll hold up the word and yeah, for for a little while so so everybody can see it. And you want to write down the word. And there'll be 3 of them. And then at the end of the webinar, email me the 3 words, and I will respond with your certificate of completion along with the materials that are used by the various presenters during the meeting. So if you have anybody have any questions about that, please raise your hand or put it in the comments. But it works fairly smooth. If you drop out of the meeting for whatever reason, just bad connection or something happens, I'll always be watching to see if somebody's trying to get in. Again, during the first session, please be patient with me if I don't notice you right away, but I'll get you back in hopefully instantaneously. All right. So before I get started on the first segment, I do want to make a couple comments. For those of you who don't know, we've had a couple recent deaths in our little document repair community. Many of you may have been aware that Sherry Koch, who's a former president of AAIP, she was president and very involved for many years, had been very ill, and she did pass away in December. And I just want to let everybody know that. And then I also want to let everybody know that my mother, Patricia Stewart, recently passed away in December as well, and an unexpected death. And she was very involved in our community from the very beginning. One of the first people to become certified, and so we'll sorely miss both of them in our community, and so anybody have any questions about them, you're welcome to contact me or email me, call me, whichever the case may be. So all right,
you don't answer.
What? Okay, so let's get started. And so the first segment, which will be a 1-hour segment, is going to be on basic deed preparation. And so bear with me a second. I'm going to share the screen and get this set up so you can all see the PowerPoint. And I do want to mention that as I'm setting this up, that the materials that I'll reference in here, I'll be sending them to all of you. Let's see. Along with the certificate of completion. Okay. Let's see. Anybody that's not muted, can everybody see the PowerPoint? Any shaking of heads? Or Eleanor, can you see the PowerPoint presentation? I do. Okay, thank you, Angelica. Okay. All right. Well, let's see. Start off with. Okay. So I chose this this particular training because, especially for those of you that do not currently offer deed preparation in your practice, this is something that you may want to consider adding. Certainly it's a very important service for the general public. It's probably the most valuable asset that most people own has to do with real estate. So it's an important process. However, it's something that I think most people can easily incorporate into their business, whether they're normally doing, other things, divorce, probate, estate planning, even, they all involved to some level, to some extent, preparing deeds. That can be greatly expanded, and it's a service that's greatly in need out there for many people. I When I was at certain times in my career, I think for many years I probably did, on average a couple deeds every day for various purposes, and that adds up. That adds up. It's a good service to kind of at least keep you afloat, and maybe help market other services as well. So. All right. So why do people need a deed? Why need deed prepared? Various reasons. They might be selling a property, either a partial sale or a full sale. They may be engaging in estate planning, and so they need to prepare various deeds associated with estate planning that we'll go over later in the presentation. It might be part of a divorce where one party is one of the parties is getting, either getting the property out of the divorce, or maybe they're just wanting to deed the property. Maybe they're both keeping it, but they need to change the nature of the deed, from some kind of a joint deed to specified interests in the property, or there may be some kind of probate going on. Whether even you're doing the probate, you still may be called on to just prepare a deed, either transferring a property out of a deceased person's estate, or again, just kind of changing the nature of the deed that's with the house. So we're going to be talking about all of those things. We're going to be looking at some samples that I've prepared to review, so you know what they look like. And as I said earlier, I will be sending, along with the materials, the class materials, the PowerPoint, I'll be sending those samples to you, so you can use those and modify them as you wish. So hopefully by the end of our presentation today, you'll have a much better understanding of deed prep for the sale or transfer of title in a home or in a property. You'll understand all of these different categories and maybe where to find more information about them. All right, so we're going to start off by talking about some definitions that are important in understanding deed work, and starting off with, what is a deed? So a deed is a document meeting certain legal requirements, and there are certain legal requirements in the preparation of the document, and just technical requirements in order to record a document that we'll go over a little bit later. But these are legal requirements which has the effect of transferring ownership or some other interest in land and property. A deed's used to determine title, and and looked at to determine who has ownership and what their ownership interest is in that land or property. The formal requirements, according to ARS 33401, are very simple, and as you would guess, it has to be in writing to transfer property. But every deed or conveyance of real property has to be signed by the grantor, and must be duly acknowledged before some officer authorized to take acknowledgments. In other words, it has to be notarized. Some key terms and considerations with deeds, and this will be, these terms will become more clear as we're looking at the documents in a little bit. But the grantor in a deed is a person or a legal entity, or maybe persons or legal entities, or a combination of the two, such as a business. When I'm referring to a legal entity, it's a person or legal entity transferring property ownership to another person or legal entity, or a combination of the two. The grantee is the person receiving it. So it's the person or legal entity to whom a transfer or conveyance of property ownership is made. And I have a note there that if the deed involves more than one grantor or grantee, consideration has to be given to the nature of the interest each person may have. So, for example, if we're deeding percentage interests, either from people that have, interest in a property that is not just in equal interest, but in percentages, we have to specify that either going from the grantors or going to the grantees, or both, however the case may be. We also, another consideration that's important with deeds is the marital status of the grantor and or the grantee. So the state of being single, married, separated, divorced, widowed. Anybody want to comment why that's important? What happens if we don't specify the marital status? And anybody wants to comment, you can just speak out.
It's because we're in a community property state.
Bingo. And what impact could that have?
Well, whether
So
it's
if we don't
considered
specify
community.
that somebody's married, go ahead. I'm sorry.
Well, I mean, my first thoughts on it are just that it's community property, and if they're going to own it as their sole and separate, it has to be stated specifically, and there also needs to be a disclaimer deed.
Exactly. We'll review disclaimer deeds today a little bit as well. So thank you. So commonly used phrases regarding marital status on a deed, or we would say, a single man or a single woman is typically defined as being a man or woman who has never been married, whereas an unmarried man or unmarried woman is usually defined as a man or a woman who has been married in the past, but is now legally divorced or is widowed. A married man or married woman as his sole and separate property, as you stated, is defined as a married man or a woman who wishes to acquire title in his or her name alone. As you mentioned, it should be accompanied by a disclaimer deed, which I think most people don't really do, which may or may not cause a problem in the future. And one of the scary things about deeds, or the problematic things about deeds, is that if there is something done wrong, it may not be discovered for many, many years. So, and it may not be discovered, it may not become a problem until the person you sold it to or you get around to selling that particular property. And then when a title search is done, something is discovered that's problematic. So big reason you want to make sure that you're doing the right thing. You're preparing these documents correctly. Couple other terms that you're going to see, or phrases that you're going to see on deeds: joint tenancy. It's a special form of ownership by two or more persons of the same property, and the joint tenant owners share equal ownership. So kind of an undivided equal ownership in the property, and have the equal undivided right to keep or dispose of the property. Rights of survivorship is another term that you'll see. Let's see. Oh, you guys can't see the PowerPoint? Okay. Let me unshare and reshare it again. Say again?
I can see the presentation.
No PowerPoint.
No PowerPoint.
All right, let me try that again then. Can you see it now?
Yes.
Yes?
Yes.
Okay.
Yes.
All right. Thank you. I don't know. Can everybody still see it now? Okay.
No.
No.
Yes.
Seems okay here.
Okay. Let me just make sure. Okay. All right. So everybody can see it now? Good. All right. All right. So I was talking about rights to survivorship. It's the power of the successor or successors of a deceased individual owner to acquire the real property interest of that individual upon his or her death. So it's a phrase that is included in a deed. Typically, you're going to see that with a joint tenancy with right of survivorship, and it's kind of an automatic thing so if two or more people own a property with rights to survivorship, if one of them dies, the remaining people on the deed just kind of automatically own, the 100% and undivided interest in the deed, and the other person kind of drops off. When I say it happens automatically, there is something that if you have a client that that comes to you where that is the situation where they have a joint tenant, for example, with right of survivorship, or community property with right of survivorship, and somebody has passed away, then the only further action that should need to be taken is to record a certified copy of the death certificate in the county where the property is located, and that effectively removes the person. Some would say, and I'd be interested in feedback if anybody has strong opinions about that. And Mary, I see you have your hand up, just a second. In addition, some people will file a formal document with the death certificate attached that a person has passed away. Mary, go ahead. Do you have a comment?
Yeah, I think can you hear me?
Yes.
Okay, so I think you kind of sort of answered. Is there a requirement, though, that you have that second statement, or is it sufficient just to do the death certificate?
You know what? I have never had a problem just recording the death certificate. I don't know if anybody else has any. Eleanor, go ahead, Eleanor. You have a comment?
Yes, in Mojave County, if you don't record another deed showing the survivor is transferring the ownership either to their name or a trust, then it changes on the tax records, but there could be a clouded title because you never changed it once the other person died or persons died. So to keep a clear chain of title, they should do a deed once one of the owners have passed away with rights of survivorship.
Okay. All right. Thank you. Thank you. Okay, Mary, you had another comment?
I do. So when she says another deed, what type of deed would I record? So when she's saying in Mojave County, I would have to record another deed, what would that deed be?
The survivor would record a deed acknowledging they're the survivor and they're transferring the ownership either to themselves or a trust or however they're transferring it.
So you're talking about an affidavit of termination of joint tenancy or affidavit of termination of community property?
No, it's a deed. You can do a simple warranty deed and transfer it. We use it all the time. Like if one of the husbands or wife has passed away, the surviving spouse can then transfer it to their trust or transfer it elsewhere, but they have to record a deed and they have to record the death certificate, obviously, to prove how they can transfer it without the other owner's signature.
So you're saying they're just recording a deed to themselves?
Correct. They would now clear the title, clear the other person's name off the deed by putting it only to themselves. When I deal with people, they usually transfer it to their own trust.
Okay.
Okay.
Interesting.
So
I've not dealt with that before, but all right. Thank you, Eleanor.
So
Scott.
can I make one more comment? So
Go ahead.
most of my clients are not transferring into a trust. So I have a wife, husband died 3 months ago. And so I record the death certificate that clears the title. There shouldn't be a question on the title.
Yeah, and that's been my experience, Mary.
Correct.
But yeah, okay. Scott Cunningham, you had a comment?
Yes, Don. So my foundation is escrow title. So this is right in my wheelhouse. And respectfully to Mojave County, the assessor doesn't control chain of title. The assessor has no voice in chain of title. They do speak up if they find an error on a deed, but Mojave County taking those additional stringencies, that is unique to them, and that is an incorrect approach by the assessor. Once a death certificate is recorded, whether you use the formal affidavit that's old school, use a cover page and just record the death certificate so the label goes on the cover page. Recording of the death certificate triggers with right of survivorship, regardless of what any assessor's preference may be. Recording of a death certificate is all it is legally required.
Okay, I appreciate that. I do acknowledge, though, it may be whether or not legally it's absolutely necessary. Sometimes it can be beneficial to to go ahead and follow whatever the nuances are, the quirks are of a particular jurisdiction or area. But I appreciate, and that's but Scott, what you're saying has been my experience in Maricopa County and other counties for that matter. Okay, all right, thank you. Eleanor, did you have another comment or? No? Okay. Eleanor, you're muted if.
Yes, in most instances, my clients are transferring it either to another individual or selling it or putting it in their trust. That's when they have to do the deed.
Okay, well, that makes perfect
sorry.
sense.
Yeah, I'm sorry, I didn't make that clear. I apologize.
Okay. All right. Thank you, Eleanor.
You're
All right.
welcome.
So let's start to go over some of the various deeds that are commonly used in Arizona, starting off with the general warranty deed, which is probably going to be the most common deed that you're going to see people use, at least as it relates to transferring property, like in the sale of a property, for example. But a general warranty deed is used to transfer an interest in real estate with warranty covenants to the buyer to defend the title to the property against anyone who's claimed an interest in the property since it was first conveyed. So even if such claim arose before the grantor owned the property, and that the estate is at the time of the execution of the conveyance free from encumbrances. So it's two parts. It's when you do a warranty deed, you're saying that, hey, there's no cloud on this title from the beginning of time, and there's no or you're saying that I'm going to defend this title from the beginning of time, and you're saying that there's no that the current conveyance is free from any encumbrance. And like I said, that's the most commonly used deed. It's differentiated from the special warranty deed, which is used to same thing. It's used to transfer an interest in property, but the covenant is limited to current or future claims made by other parties that arise during the grantor's ownership of the property, but not before that time, as it is in a warranty deed. So let's take, if you'll bear with me, let's see if we can take a look at a couple sample deeds like that. And please, I'll tell you when I have it open. Please speak up if this is not something that you can see. So I have the deed up. Can everybody see the deed?
Yeah, the deed is showing.
Yep. Thank you. Okay. So this is a typical warranty deed. You have your grantor, in this case is Jane L. Doe, an unmarried woman. As I said, the undersigned grantor, and she transfers the deed for valuable consideration to Janet A. Smith, an unmarried woman. So just like the terms that we reviewed already, we have the grantor's name, the grantee's name, we have the marital status specified. And then we're gonna list the legal description of the property, the assessor's parcel number of the property. In my experience, the legal description is really all that's required. Although I always include, I almost always include the assessor's parcel number as well as the address of the property. And then, you see here this little phrase, the little phrase down here, the covenant, that they're warranting title against all person whomsoever, subject only to those encumbrances or liens of record, or as above set forth, if any. So there's your covenant. And then as we reviewed before, it's signed, it's notarized. The only thing I didn't talk about here is these exemption from affidavit. So I'll talk about that shortly. We're gonna look at the special warranty deed first, and then we'll talk about an affidavit of property value, what that's all about. Oh, here we go. Special warranty deed. So again, same provisions that you saw in the regular warranty deed. A difference here is the covenant. The grantors bind themselves and their successors to warrant title against their acts and none other, subject to the matters set forth above. So that's the major difference with the two different types of deeds. So now whenever you transfer title, just a second. Whenever you transfer title to a property, Arizona law requires that an affidavit of property value also be completed unless the transfer is, for whatever reason, exempt from the requirement. And so really with any sale, this has to be completed. And this document goes to the assessor's office. And then from there, I don't think anybody really knows what happens to them. And I chuckle when I say that, but it's important to know that if somebody doesn't properly, so there are exemptions to having to do the affidavit of property value. However, and I'll go over those in just a moment. But I guess first let's just kind of look at what's required in here. You have the parcel number. There's names of buyers and sellers. What type of deed or instrument is used to transfer the property, what the sale price of the property was, if there's personal property included. So these are all provisions that that the assessor's office wants to know about. Now, so this has to be included and signed by the parties and notarized by the parties when the deed is submitted. Now this is a list of exemption codes. So, some exemptions, would be obvious probably. For those of you who do estate planning, maybe do trusts, that's a type of an exemption, that's a type of transfer that is exempt. If you have, we can just go through some of these, a deed of gift, transfer to release security on a debt, a transfer that confirms or corrects a deed that was previously recorded. B3 is a common one, a transfer of residential property between family members, and between certain family members with only nominal consideration for the transfer. Transfers to a trust, transfers if you've got businesses, in your merging companies, transfers between husband and a wife, to create like community property with rights to survivorship, for example. So there are a number. The vast majority of deeds that I have ever prepared are included in one of these exemption codes. If you are wrong about this, though, if you put an incorrect exemption code, or you put an exemption code where they should have done an affidavit of property value, it actually is a crime. Now, the question that's always been in my mind for, probably close to 30 years of doing these types of deeds is, okay, how do they find out if you did it wrong? How do they make that determination? I don't know if any of you, I'd be curious to hear from any of you that have researched this issue, but there was a time, probably, it was quite a while ago, probably 12 years ago, where I dedicated some time to find exactly who reviews these affidavits and how they make a determination if you have incorrectly listed an exemption. And my research revealed that no one does. Now, whether that's entirely true, I can't guarantee you of that. But that's what I was told. Again, I'd be interested to hear if any of you can reveal more information about that. So Scott Cunningham says, it's my understanding. That is my understanding too. Okay. Actually, I want to look at Scott's, yeah, that's my understanding too. Now, if a lawsuit arose, that's probably where the hammer drops. That's probably some good advice, Scott. So obviously we want to do it correctly. Sometimes I've had some situations in the past, and many of you probably have, where it's not exactly clear cut, or you have a client that insists that one particular exemption is applicable to their situation where it is not, where you don't think it is. So there might be an ethical question as to whether or not you should decline the job. But anyways, that's always it's something that bothered me for many years. And as I said early in the conversation today, there have been stretches of time where I did a lot of deed work. And so I was very concerned about this, but I've never been able to get a completely straight answer about how they make those determinations. So let's see, we'll get out of a couple of those and go back to the PowerPoint. Okay, let's look at a few other deeds. So we have quitclaim deeds. Quitclaim deeds are used to transfer whatever interest the grantor may have in property to a grantee or grantees without warranties of any kind. So just to look at take a look at a regular quitclaim deed. Actually, let's see. I have a quitclaim deed, a quitclaim to joint tenancy. So this is one
John,
I probably, yes.
I'm sorry, I hate to, a couple of things on what you were saying before.
Okay.
Okay, I have first on the affidavit of value. If all else fails and they don't qualify for something else, many times they default to that gifting part, and so that could be a problem. So somebody comes in and says, "Oh, but you gifted me that," and so just that comment,
right,
affidavit. But my question to you is, if I have a warranty, a special warranty deed, and I don't have that phrase in there, is that a problem?
That's a good question. Yeah, I would think so.
Okay.
I mean, so in other words, you've got a heading that says special warranty deed, but you don't have the phrase that the covenant phrase.
Yeah.
Is that what you're saying? Yeah. Yeah. I mean, it's an error. I think it's an error. Yeah. I would say if it's not there, then it's not a special warranty deed.
Okay.
Okay, Chris, we got a couple comments in the chat. Let me read. Okay, okay, so Chris says to go back a bit. ARS 33-431 F says that an affidavit with the DC should be filed. I do it as good practice. Okay, Scott Cunningham says if you don't have the special warranty deed clause, it will not be a special warranty deed, even if the heading says that. And that's my opinion as well. And then Lupita says as a gift deed, may have a problem with the IRS. Okay, well, yeah. And then Susie Thompson suggests that we ask your title company. Title companies are valuable resources. I have found that as well. They're also great sources of referrals if you start to develop some relationships with some title agents. But yeah, I would think that you would have to have that provision of that clause in here. So back to the deed that we're reviewing. This is a quitclaim deed. It happens to be a quitclaim to joint tenancy. And so in this case, I think this is an example, and probably a common example, that those of you that do or want to do or are planning on doing some deed work in your practice from one spouse to the other spouse, or to the two of them, really. So John Doe is in this example, it appears John Doe acquired a property as a single man. He's now okay, all right. So he's a single man, and he's deeding it to himself and another person who is also single, and as joint tenants with right of survivorship. So the net effect of this is that they have an undivided equal interest in the property. If one of them passes away, the other one will automatically own 100% of the whole, and all they'll need to do is record a death certificate to remove that person from the property. And I would say, if John Doe and Jane Smith, let's say maybe they're brother and sister, then there probably is an applicable exemption from the affidavit of value. And then it's also important with joint tenancy that you can't just deed it to joint tenancy, the right of survivorship. There has to be an acceptance by both parties, or by all parties, however many parties there are that are acquiring the title in joint tenants as joint tenants with right of survivorship. They have to accept that as joint tenancy, and not just as tenants in common or as community property. They have to make that assertion. So hopefully that makes sense. But yeah, and again, the main key provisions are very similar in all these, with the grantors, the grantees, the signature, the notarization. But yeah, it's important to note for joint tenancy deeds, they have to be accepted. I have had in probate cases I have worked on, I have had old deeds. I haven't seen any recently, but I've had old deeds where there were deeds to joint tenants, but there was no acceptance signed. And I've also had situations where it was kind of hard to find, that it wasn't apparent. It had to be looked at very closely. But I've definitely had situations where there was no acceptance, and thus we had to. It was a probatable situation to deal with that, because the acceptance wasn't signed. So let's see, go back to the PowerPoint. So the next one is a disclaimer deed. We talked about that a little bit a little while ago. Disclaimer deed is a deed in which a spouse disclaims any interest in real property acquired by the other spouse. So somebody's buying property for whatever reason, and they're married, and they don't want for whatever reason, they don't want their spouse on the deed with them. They're not going to have the spouse on the deed with them. They should specify their marital status on the deed that they're acquiring, but they should also, in all cases, in my view, have their spouse sign a disclaimer deed. Now, sometimes spouses are not willing to do that for whatever reason, but it's something that should always be done. Can anybody out there, anybody in attendance, want to share any problems that they've seen in their practice with situations where disclaimer deed was not shared? So Rob Merrill, go ahead.
Really more of just a comment than anything. I have a form that I make them sign when we do deeds that kind of releases us of liability. And one of the things in that that liability waiver is a section that says, hey, I've been informed that I need a disclaimer deed on this property, and I've chosen not to do it. So if I get a spouse who just refuses to do it, but the person wants to go forward with the deed, then I'll make them sign something saying, I understand I have that. It's going to cause a problem in the future, probably going to cloud title, but I'm doing it anyway. And on top of that, just generally speaking, I see that's probably the biggest reason I do probates is because of that disclaimer deed. And I get tons of referrals from title companies because those disclaimer deeds are not done or not done properly.
It's a great point. Yeah. It's surprising how prevalent that is, but it is just often it's just spouses not wanting to get other spouses involved in business deals. I think sometimes it can be a bit of a cultural issue. But it's whatever the reason, it can be very problematic. Thank you, Rob. Scott, did you want to say something?
I was just curious because we do have a duplication in understanding things. I'm just curious because I would never, I would refuse the deal if the spouse didn't want to do a disclaimer. Because it seems to me you're probably putting yourself into a potential liability situation when they now have to go through probate or something, or the property gets passed on DIY style for 3 or 4 transactions, and then it goes to a title company, and they find your document is the one that created the fraud on title. You may not, you may come out of it clean in the long run, but you're still going to get called into deposition and all of that. So it may not be right or wrong, but I would try to think through the kind of liability am I going to expose myself to with my foundation in the title industry. I would never do that.
Yeah, no, I think
I wouldn't cloud title that way.
that's a fair comment. I think that's probably a prudent practice to just not take the case. Whether or not, I mean, I don't, whether or not you'd be liable for what happened, I don't know about that, but I certainly think it's prudent practice to make the decision to not take the case if you know that it's not really being done correctly. It's that's we're not giving people legal advice on the consequences of what can happen. So I don't know that we can be held liable for it, but at a bare minimum, like you say, you may be setting yourself up for in the future, and maybe long in the future for a major headache. So I definitely appreciate that. So thank you, Scott. Rob, any other thing, or you just got your hand up still? Okay. All right. So let's see. We've got disclaimer deeds. All right. So these are the most common deeds that you see prepared. I want to briefly now just kind of go over, what do you do? You got a client that walks in the door, what are some good practices in gathering information that you need? What information that you need to prepare deeds for people? And so this is just kind of an outline of what I would typically do. So information, obviously probably the most important thing you need, which is not always the easiest thing to get, depending on what county you're working in, is getting a copy of the current deed. Why is that critical? It's critical to obtain the copy of the existing deed to obtain the exact name, the way it's written, of the current owners of the property who are transferring the property or their interest in the property to another person. And so you can see how their marital status is listed, and you see the exact legal description on the property. What I typically do, if parties don't have the deed, clearly you can go on the county recorder's website in whatever county you're doing business in. But I will usually, in Maricopa County at least, I will usually start with the assessor's office. Look up the property in the assessor's office, because the last recorded deed will be connected to the information from the assessor's office, and I just find that simpler. Whereas if you just do a search on the recorder's office, you may, it should be evident which is the most recent deed, but it's just more of a to-do to find it. And so for example, let me see if this will work. So yeah, I'll go and to the assessor's office and let's see. Well, oh, here we go. I tried when I was preparing for this. I tried to find, I don't want to just look up somebody's property, but I tried to find some like foreclosed property that it wouldn't be a big deal. And so, so just type in the address. See if this works. Yeah. So you find the property, you scroll down, and you're gonna find the most current deed that's been recorded, and that pops you right over to the county recorder's office, and you can open the deed. I mean, that's probably most of you knew that already, but I just thought I'd go through that exercise. I find that as the most effective and the quickest way to find a deed in Maricopa County. Different counties have different systems that may or may not be connected. So that's okay. So that's finding, so the deed for that critical information. The other information obviously you need is the information about the grantee or the grantees, the exact name of each grantee, their marital status, how the grantee will want to hold title, whether that's joint tenants or community property with right of survivorship. So these are all factors that you want to know. Now, and I'll send this to you if you want to use this, but this is a little questionnaire that I put together many years ago that I just used to gather this information. What's missing from this that I normally have in here is that, and hopefully most people do this, but I have the written disclosures in here that all document preparers are supposed to usually have a page of the disclosures we're required to make. Any other disclosures that like Rob was talking about, maybe that you want to have in here for people to read and sign that they read. But then, this is, I have clients fill out this information. So, it's crystal clear. I went over these details with them, what I needed, what the legal description of the property is, what the address of the property is, where the county is, what kind of deed they want prepared. And then it directs them to the different types of deeds. So I will send this to all of you as well. And if you want to use something like this or use it as a basis to create your own questionnaire, I'm big on questionnaires. I think it's almost always the best thing to have clients in writing give us the information that we're looking for. And that way, if hopefully nothing ever goes wrong, but if something does go wrong, we have the documentation as to where the information came from. So thank you, Kevin. Kevin loves the questionnaire. So I know I missed a few comments in the chat. Let's see, I'm just going to read a couple of them. So Scott Cunningham said the inheritance is not exposed to community property, and a beneficiary deed is a type of inheritance. So the beneficiary, okay, we're going to talk about beneficiaries deeds in just a minute. Okay, well, all right. So yeah, we'll move on to the next. Okay, so that's generally speaking, that's all the information I wanted to give you generally about deeds. I wanted to touch on a couple other issues with deeds. Of course, we really already talked about the joint tenancy deeds. So these are estate planning issues with deeds. There's the joint tenancy deed with right of survivorship. There's that we've already spoken about. There are beneficiary deeds. I think there's a tremendous opportunity to provide this type of service to the general public, that the general public that is not interested in doing a trust, not interested in in doing other types of direct beneficiary designations. Doing a beneficiary deed. Beneficiary deed is a deed that is prepared now. It's recorded now, but it's not effective until the maker, the grantor passes away. And it basically, it's a simple deed. It basically says, upon my death, I want the following legally described property to be distributed to the following person or persons. And a big difference with other deeds and a beneficiary deed is that a beneficiary deed, to be effective, has to be recorded now, whereas other deeds are really effective upon signing. Now, I'm going to qualify what I just said a little bit. Even though, it's my understanding that deeds are other types of deeds, warranty deeds, for example, are effective upon signing. It can be problematic if they're not recorded in a timely manner. I'll give you an example. I actually had I had somebody that I helped not long ago that did a trust. Let's say 15 years ago. They did a trust. A deed was prepared to transfer property that they owned into the name of their trust. It was signed, it was notarized. However, for whatever reason, the person that signed the trust, who owns the trust, never recorded it. And that person died probably about a year after they signed the trust, or after they signed the trust, after they signed the deed. And then fast forward, I guess the family was living on the property for 15 years, and they finally got around to deciding to sell the property. And even though they had the deed that had been signed, notarized, the title company involved with the sale required them to open probate, asserting that they basically asserted that we don't know that this person changed their mind about using the trust because they never recorded the deed. So I thought the rationale was a little screwy, but that's basically the position that they took. So anyways, beneficiary deed again is it is a very effective tool. Just like any direct beneficiary designation, like a POD or a TOD that you might use with bank accounts, or a beneficiary deed is effective upon death, and all that needs to be done is a death certificate needs to be recorded in the county where the deceased property was at, and that effectively transfers title over to the people that are named in the beneficiary deed. And you can do beneficiary deeds too, that transfer to people as tenants in common or as joint tenants. With right of survivorship, you can have alternates on beneficiary deeds. So it is a very inexpensive, very simple method of estate planning. I'm sure many of you estate planners out there, or people that do estate planning documents, can find problems with using a beneficiary deed. It's not for everybody, but for many people, it's effective and at least meets their needs for the most part. A deed to trust. I mean, the deed to trust is basically either going to be a warranty deed, special warranty deed, or a quitclaim deed, transferring the property, which we've reviewed, transferring the property into somebody's living trust. But as many of you have probably experienced, there are a lot of people out there that have trusts where they never transferred their property over, or maybe they had a trust prepared and they moved and bought a new property and that was never done. So there, again, a lot of work out there for, potential work out there for people that just have not done these transfers, and the trust is no good to them if they don't actually put the property into the trust. Okay, and there's a lot of comments going on. I'm not sure if anybody making comments, because they're going a little fast for me to catch. If you think it would be helpful to talk about whatever you're commenting on, please raise your hand, and we'll do that. Okay, let's see. We're almost done here. Just a couple other comments. Oh, go ahead.
Can you hear me?
Yes. Who's this?
Okay.
Is this Mary?
No, this is Susie.
Susie. Okay.
Yes.
Right.
Okay. So the comments that we're talking about have to do with a beneficiary deed being granted for a deed of trust where an owner does a carryback on a property. They want to make sure that if they're deceased, that their heirs successors get that that money per se, even though it's a lien. But if something happens, then they're going to be in probate trying to get it, because even though you don't probate personal property, you still have property when you do a deed of trust, you do an owner carry. So I have clients that want to do a beneficiary deed for their deed of trust, and they were told by somebody that they could do that. And so Don, yeah,
Rob?
that's what we've been. Yeah, Rob,
Okay.
Rob and I've been kind of going back and forth with that. So I don't have the verbiage for it. I know it can be done. It's just a matter of
Okay.
how do you write it so that it's clear and doesn't create a cloud on title.
Yeah, I don't know.
So are you saying that you're going to do a beneficiary deed over to the lender so that when the signer of the deed of trust dies, then the lender gets the property?
Okay, so when you do an owner carry, you are the bank, you're the lender.
Correct.
Okay, if you die, who gets the property? Who gets that income? Because it's still going to go through, it's still going to have to be paid. Somebody's going to have to take over that. And it's just another estate planning tool that you can use.
I don't
Well,
see how, because on a beneficiary deed, they're going to get the whole property then. And the deed of trust actually talks to that inures to the heirs and assigns in that deed of trust. And so the holder of the note can then go in and they can actually open the probate if need be. But I'm bothered by the idea that there's a beneficiary deed out there. So let's say I lent you $20,000 and put a deed of trust on your house, and then you gave me a beneficiary deed. You paid me $10,000, but
I'm not the one. No, I'm not the one giving you the deed. I'm not the one giving you the beneficiary deed. You, as the bank, are doing a beneficiary deed for your heirs and successors so you can avoid probate. That's the whole purpose of doing that.
Okay,
It's been done. Title company does it.
I see.
It's
Okay,
just a
I
matter
see
of
what you're
finding
saying.
that verbiage.
So what you're saying
Hey,
is
hey,
the deed of trust
excuse
is
me.
personal property and not real estate property.
All right, go ahead,
Okay.
Alan. Go ahead,
Yeah,
Alan.
the deed of trust is the mortgage, basically. And it has nothing to do with the transfer of the property. It has to do with security on the property is security for the loan. But whoever inherits the property is responsible for the loan, because the property continues to be security for the deed of trust. So there's really not a connection there. And it doesn't change the obligation of whoever owns the property to make those payments or lose the property. And so I don't really see the issue there. If you do a beneficiary deed, and someone and let's say your son or daughter inherits the property, they also inherit the obligation to pay that deed of trust, to pay that mortgage, basically.
Correct. However, you still run into the issue, even though it says your heir successors and or signs, you're still going to run into an issue, because even though the deed has transferred and now it's just a money obligation, you can still find yourself in probate, because now who's got authorization if those people default? Because the banks are one thing, but when you do a personal, it's a little different. It's been done. The title company says you can do it, but nobody has a form. And my clients are asking for it. And so I just, thought, hey, maybe somebody else has done them. And
well, are you saying that if they don't pay the loan, then it goes into probate?
Yeah, okay, so the people that carry the note die. Okay, we know that notes all say,
Well,
you
the
know,
people that carry, people that carry the note,
Yes.
the beneficiary of the deed of trust.
yes, the beneficiary. So basically you're doing a beneficiary deed for the beneficiary of the deed of trust,
Oh,
I
okay,
guess.
yeah.
Do you see what I'm
Yeah,
saying? So,
I can see what they're trying to do.
right.
And
And I can see that it wouldn't be a problem, but you know, they're pretty adamant about that's what they want to do. And I'm like, well, I don't know if I can do it. It can be done. I've asked the legal department at the title company, but they haven't said anything yet. So.
I can see where it would be a form of beneficiary deed, except that the way the beneficiary deed is described in the statutes does not apply to financial obligations. It applies to specifically to property.
Right,
So
but
I
if
they
the
could
people
maybe make
default,
something up along those lines.
right, but if the people default, then it becomes a property matter because now you have to foreclose on that property and you could end up having that property back. And that's
Yep.
where
But
that's
so
where it
that's-
could be an issue, but I'm
Yeah.
just, you know, throwing it out there because, you know, I have clients that are.
I'm
wanting
sorry,
to do
that's
that.
the nature, that's the nature of the deed of trust. That's the nature of it.
Yeah,
Yeah,
I know.
it
I'm in
And
real
so
estate,
you
so
can't-
yeah, I know, but.
And I agree with Alan, that's a beneficiary deed, and deeding goes to real property. That deed of trust, and if I own that deed of trust and I was the lender, I have a personal property interest in it. I do not have a real property interest in it, and I would have to go through foreclosure if they didn't pay. And what's the big deal about going to probate? We have.
I know, right?
Well, okay.
So easy now.
As long as I'm on the line here, I'd like to bring up something else about the deeds, Don. Oh, I see you're on the phone, so.
Sorry, I'm trying to help somebody get back in the meeting. Go ahead, Alan.
Okay, yeah, one of the deeds that you didn't post on here was, and I think it's an important deed, is community property with right of survivorship. And having a tax business, or having had a tax business, I'm retired now, but having had a tax business, there's a couple of issues there. One that I've seen come up, one of them is the difference between a joint tenancy deed and a community property with right of survivorship deed. Now, of course, community property with right of survivorship can only be done by a married couple into the as the receiver of the property. But there is a difference in how taxes are handled if the property is sold. So if you have a joint tenancy deed, if you hold property in joint tenancy with right of survivorship, and that property, one of the parties dies, the party that died, their side of that, their half of it or whatever, it gets a stepped up value of the basis of the property, which is fine, except that the other side doesn't. So if the person goes to sell it, they're going to have some capital gains that they shouldn't have to have. So if the couple is married and they do a community property with right of survivorship, both sides gets a stepped up value if one of the parties dies. So that's an important issue there. It can become a very important issue. The other question I wanted.
Alan, along that line here, I'm sharing right now. It's something I didn't get to, and so yeah, here's a warranty deed, and then here's the acceptance of community property with right of survivorship. Is this what you're talking about?
Right. Yeah.
Yeah.
And
okay.
And that's really pretty important sometimes. And the other question I had was, though, in the quitclaim deed, one of the title people that I've dealt with in the past, one of my clients who's now a retired title person, said that quitclaim deeds terminate any prior title insurance obligations. So, and that's one reason for doing a warranty deed, is that it kind of continues on some prior title insurance that might be hanging out there. Let's say there was some error made, 25 years ago. The warranty deed helps to continue that obligation. It doesn't continue it on current stuff, but it continues it on what may have happened 25 years ago. So I don't know whether that's an issue or not, but it's one that I've always kind of, when we did trusts, and I'm sure when Rob does trust, we use warranty deeds only. We don't do quitclaim deeds anymore. We used to when we first started, but we changed that to warranty deeds.
Right.
So
All
that's
right.
it.
All right.
I'm done.
All right. Thank you all for great participation. I appreciate it. We're going to wrap up that segment and move on to our next speaker in just a second. Our next speaker is Brian Locker, and I want to get him set up before we get into Brian's presentation. And Brian, if you'll hang in there just a second. Brian, are you there?
Yeah, I'm here. Can you hear me okay?
Yep, I can hear you. Yeah, I'll spotlight you in just a second. Before we get into that, I want to hold up the first word of the day. So these are the magic words, one of 3 that you'll need to send to me after the webinar is ended in order to get your certificate of completion. So the first word of the day is watch. Let me hold that up here. WATCH. Okay, I'm going to hold it up there for a minute. Please write this word down. Again, you want to send me an email with the 3 words in order to get your certificate of completing the webinar. Okay, everybody got that? I know sometimes people step away. I'll probably I'll hold this up one more time just before Brian begins.
So on your screen, your magic background is blocking out the word.
Oh, it's distorting
because it doesn't see a person anymore.
Okay. I guess I need to. I guess you're going to need to see my messy background. Let me fix that.
Or you can just hold it up under your face.
Oh. Is that all right?
Yep.
Okay. So watch. WATCH. Perfect. Okay. Thank you, Patricia. All right. Okay. So let me. I'm gonna spotlight Brian and let Brian take over, and bear with me just a second. Okay. All right. So our next speaker is Brian Locker. Brian is an attorney who has presented many times for us throughout the years. We appreciate him very much. Brian's going to be reviewing the topic of the ins and outs of real estate litigation. And so, Brian, I will let you take it away.
All right. Can everybody see the presentation okay? I guess Dawn, maybe you can confirm.
Yeah, I can see it.
All right, perfect. All right. Well, thank you, Dawn, and hello to everybody that's here this morning. My name, obviously, is Brian Locker. I'm one of the partners at Fowler St. Clair. For those of you unfamiliar, I co-chair the real estate litigation practice group for the firm, and I'm privileged to be able to talk to you this morning about what I do day in and day out. And people often ask me, well, what exactly is it that you do in real estate litigation? And really our discussion this morning is really an overview of and sort of a peek into what I do every single day. And so if for no other reason, I think the goal of the presentation this morning is to help those of you who are in front of people every single day with different issues that may involve real estate. I was listening to the discussion there at the end of the last segment, talking about deeds and whether whether to do quitclaim deeds, warranty deeds, issues regarding the acceptance of property as joint tenants with rights of survivorship, and all of these things actually play into some of the issues and many of the issues that we end up addressing, because it sort of to Alan's point, if you don't get the deed right in a real estate transaction, there you are often creating title issues for that property that will need to be addressed down the road. And so I want to certainly affirm sort of the importance of carefully preparing deeds, because it's something that may have to be addressed at a later date. So that is sort of the an overview. I'll give a little more specifics here. Let me figure out how to progress my slides. There we go. Purpose of the discussion. I emphasize discussion. I usually don't even have to mention that for the folks with AAIP. You guys are usually very good about chiming in with questions, and I invite that. And so if I don't see a question come up on a particular topic, I'll usually pause before I move on to the next one to see if there's anything that maybe I made unclear, or if you have a question or a situation that's come up in your in your business recently. We're happy to just kind of dialogue about that as we move forward. So let me talk briefly here about where I want to go with this. So the 6 main topics that I'll be hitting, and I've sort of weighted them more heavily at the top of the list than at the bottom in terms of the time I'd like to spend on them. But the number one issue here that is actually most prevalent in my practice is quiet title and slander of title, 2 very similar but distinct type of actions. And so we'll go into what exactly all that means. Topic number 2, we'll talk about partition. So when courts need to get involved to actually sell real estate, we can talk about some of the issues that are presented in those actions, which we see quite often. Number 3, judicial and non-judicial forfeiture, not to be confused with foreclosure. And so we'll talk about that. Number 4, we'll talk briefly about forcible entry and detainer, so evictions. We can talk about those. Judicial, non-judicial lien foreclosure, and then wrap it up if we have some time with eminent domain. So I did get one notice. I saw a chat from someone saying they can't see the presentation. If there's anybody else that can't, I can always switch to just sharing my screen as opposed to directly sharing my PowerPoint. But so just let me know if that's a problem. Okay, so first, before we get into quiet title, there's some advice that I got a long time ago that I think was very important, and that is, if you're dealing with real estate based litigation, or even just real estate issues generally speaking, one of the best things you can possibly do is to find a good title company. A title company that is willing to work with you, because title companies deal every single day with issues that arise from real estate and deeds and that sort of a thing. And finding someone that's willing to work with you to work through some of these issues is absolutely imperative. And so we have a number of title companies that we work with regularly. And one of the things that we get from title companies is something called a litigation guarantee. Oftentimes when you are involved in real estate litigation, and frankly, most of the time, it's dealing with some sort of adverse interest in real property. And one of the things that we can go get is called a litigation guarantee. And what a litigation guarantee, you can see here on the slide, is it's an insurance policy that is issued in favor of the attorney or the attorney's client and the client in the action affecting land. A decree in a real estate action is only binding on the parties named as defendants, which should be the same as parties claiming an interest in the land. And so what does that mean? Well, basically, if I'm going to have to go and I'm going to have to initiate litigation, I'm going to have to go file a lawsuit in order to try to clear some sort of an issue with title. I want to have assurances that that this is the last time my client's going to have to deal with this. And so what a title company will actually do is they will actually guarantee our lawsuit. They will actually say that if you bring the lawsuit in the way that we describe in our policy, almost like a title policy you get when you buy a house, if you bring the lawsuit against these certain people in this certain way, then we will actually guarantee that when you're done with the lawsuit and you get a judgment, that title will be clear, and you'll be able to sell the home or whatever it is you're attempting to do with it. You'll be able to dispose of the property, and we'll guarantee that to the point where if more litigation is necessary, the title company will pay for it. So that is something that's really important. And Dawn, just as an aside here, it looks like I was listed as presenter, but now it says that someone else has been appointed as presenter, and so it's not giving me like my presenter notes or anything. So I don't know if that's
Okay,
something you
let
can
me
fix on your
let
end.
me fix that. All right. So, oh, it still has you as spotlighted.
I'm spotlighted, but I'm no longer presenter, and so I don't have like any notes or anything. It looks like
it's not. I don't see. It's not giving me an option to do that.
all right. Oh, here we go. I just took control again. Okay.
Okay. All right.
All right. Okay. So how does litigation guarantee help me? You can see here basically what I just described. It helps ensure that I've named the right parties, helps ensure that that I know my client's lien position, and it provides confidence to the client that the litigation will be final. So that is the reason why we do it. Even for those of you document preparers and this is something that can be recommended to a client. This is not something that needs the involvement of an attorney. And so if this is a practice area, where you are dipping your toe, this is something that can be very, very helpful. All right. Let me see here. All right. So let's jump into our first topic, quiet title. Quiet title is sort of a broad term of any time that you need to bring an action to clear a property's title, and I sort of break it into two parts. Part number one is adverse interest under ARS 121103. So let's talk about that first. ARS 121103 is a statute that provides a very specific remedy. So let's take a look at this here. An action under 121103, and really there's a number of related statutes. So you'll see I have a 121101 et sequitur. That just means that there's a sort of a group of statutes there that deal with quiet title. So these actions are brought by any party having or claiming an interest in real property against any person or any state claiming an adverse interest. The complaint that is brought under these statutes must be under oath, must describe the premises, so describe use the legal description of the property, set forth the adverse claim, and pray that the defendant be barred and forever stopped from claiming any interest in the real property. So how does this come up practically? I was sort of thinking about this this morning, and the three most common scenarios here in which I'm myself bringing a quiet title action under this statute is number one, when you have a real estate investor who is purchasing a property from a homeowner. And this is something that has come up a lot more recently, where you have this just an explosion of cash buyers in Arizona. And what will happen is you'll have a seller who is selling their property, and they go under contract with a real estate investor to sell their property at price A. They sign a contract. They then are contacted by another real estate investor who offers them a little more money. And so they sign a contract with them. And so now we have two contracts that are both signed by the seller and with separate real estate investors. And both real estate investors then go and record liens against real property, against that real property. And there's a fight that then ensues against the real estate investors and against the seller themselves, who, for whatever reason, decided to sign two contracts to sell their property to two separate people. And so we end up going in and as the person with the highest interest in the property can bring an action under this statute to say, look, we are in the greatest position here, and we need to clear title as to these other people. So that's one scenario. Scenario number two is we've got lien holders. And so let's say that you're an owner of a property and you had a loan with a private individual, right? And you signed a deed of trust to secure that loan with your property. And let's say you paid off the loan. But for whatever reason, the lender just didn't release their deed of trust. So now you're going and trying to sell your property. You have long since paid off this loan, and you go to sell the property, and you learn that this deed of trust is still out there, and the lender is no longer around, or maybe they are around, and you're like, well, why didn't you release this lien? And maybe there's a dispute over whether the lien was properly paid or whether the loan was properly paid off. In any event, you have this statute that allows you to now send notice to this person to say, hey, look, you need to release your lien. So that's another way that can come up. And then finally, we see 121103 and the related statutes come up when we have neighbor disputes. So let's say somebody builds a fence, right? And the fence is arguably on, not over the boundary line, but it's actually on the neighboring property's line. And let's say nobody noticed for a while. And so now that fence or that wall or whatever it is, that obstruction is by virtue of the fact it being on a neighboring property is potentially an adverse interest in real property. And so these statutes allow for a remedy for that. So what's the major benefit of this action? Well, it's this statute actually allows for costs and attorney's fees. So you'll see here under 121103, if a defendant appears and disclaims interest, she shall recover costs. And if a plaintiff can recover attorney's fees and costs if she tenders a quitclaim deed and $5 to the adverse party 20 days before bringing an action. So basically, the way that this statute is designed is to require parties to notify the party they believe is claiming an adverse interest. So if I'm going to bring a lawsuit under this statute and I say, look, there's this person out here who I believe is claiming some sort of adverse interest in my property, I'm going to have a right to collect attorney's fees from them and my costs when I go and I clear this person's adverse interest. But before I can do that, I need to not only just send them written notice of my intent to bring an action to clear the title, but I actually have to deliver to them a quitclaim deed, giving them an opportunity and a $5 check to cover whatever recording fees they may incur, and say, look, I'm going to try to avoid all of this at the outset. So before I bring a lawsuit against you, here's a quitclaim deed, here's $5. You should disclaim your interest in my property. And if you do, no harm, no foul, essentially, right? But if they fail to record that deed, or if they if they ignore the warning that you're going to be bringing this, and you are forced to do so 20 days after you send this notice, the court if you win, the court will actually award you all your attorney's fees and costs. So why do they do that? Well, courts don't want to have to get into disputes regarding claims to real property. They only want to do so if there's a legitimate dispute, and so this statute is sort of designed to try to get people to work things out outside the court system. But if they can't, there is a punitive nature to this where the person who has to bring the action can actually collect their attorney's fees if they set it up right. So that is number one under quiet title. Number two is actual slander of title, and this is something that we see even probably even more frequently, and oftentimes there are claims both under 121103 and under ARS 33420. ARS 33420 is Arizona's slander of title statute. You'll have a statute that resembles this in most states, although Arizona is unique. Well, I should back up. So I practice law in both Arizona and Georgia, and so when I started practicing in Georgia, I was very familiar with all the Arizona statutes on real estate, and when I went looking for a statute that was similar to ARS 33420 that we're about to go through, I came to realize that actually it doesn't really exist in the same way that Arizona has set theirs out. And so they are, it is interesting that Arizona has chosen to have a statute sort of like this, and you'll see why when we start going through here. So what is ARS 33420? ARS 33420 is a statute that essentially says that if you are a person who claims an interest or a lien or an encumbrance, something that is adverse to the interests of the actual owner, and that could take a variety of different forms. But if you are a person who does that, and who are claiming an interest, and that interest is wrongful, right? So not just that it's an honest dispute between two parties, but that you are wrongfully claiming some sort of a lien or interest in property. This statute lays out the kind of remedies that you as an owner of property have available to you. So let me sort of walk through exactly what that looks like. And there's a couple of different scenarios that are contemplated under this statute. Under subsection A, it says a person purporting to claim an interest in or a lien or encumbrance against real property who causes a document asserting such claim to be recorded in the office of the county recorder, knowing or having reason to know that the document is forged, groundless, contains a material misstatement or false claim, or is otherwise invalid, is liable to the owner or beneficial title holder of the real property for a sum of not less than $5,000 or for treble the actual damages caused by the recording, whichever is greater, and reasonable attorney's fees and costs of the action. So right off the bat, when you read this, what should be going off in your head is, wow, that sounds like potentially a lot of damages to whoever is claiming an adverse interest if they lose. And you would be right. I have an action in my office right now where my client was claimed to have a wrongful lien against another party's property. And the damages that they are alleging in that case are 3 times the loss of value to the property during the time in which the lien was in place against the property. So let me tell you what I mean by that. So my client filed a lien against a property. And the reason why is not really material for our discussion here. They filed a lien which essentially prevented this owner from being able to sell their property. The lien was in place from June of 2022 until January of 2023. So a period of about 8 months. During that 8 months, they allege that the property dropped in value, retail value, by $180,000 during that 8-month period. Now, I find that a little dubious, but let's just say that they're correct. What this statute potentially allows that owner to do and claim against my client is 3 times the amount of that decrease in value. So we're talking about an action for nearly $600,000, plus the owner's costs and attorney's fees to bring the action in the first place. So that is the kind of punitive outcome that can occur here if you are the one who is in fact claiming an interest in the property. And so I say all that to say, if you are someone who's claiming an interest in real property, or you have a client who wants to go and record an interest in real property, whatever that might be, and you think it might be adverse to someone else, it is important that these people understand the potential repercussions of a recording like that. It is very important that when you go record things that affect real property, that you do so correctly, because these are the kinds of statutes that come into play when they are incorrect. So all right. So Alan, I see you got a question.
Yeah, hi, Brian.
Hi, Alan.
Do you know when this statute came into being?
That is a good question. I can give you that answer in just one moment. Let me see here. ARS 33420. I've got LexisNexis pulled up right now, actually, so I can just scroll down. Let's see. 1992.
Oh, well, I wish I'd known about it. I had a client who had a situation just like that. It was very kind of an inexpensive property, and so there wasn't a lot of money involved. And fortunately, we kind of called. We sent the $5 and the quitclaim deed to the guy, and he kind of dragged his feet on it. But then when we said, if you don't do this, my client's going to file a quiet title action, and you're going to end up with legal fees and so forth. And you did so, and he actually had forged a deed.
Yeah.
So
that's really bad.
Kind of got it straightened out, but I wish I'd known about that at the time. That shows you the difference between being a lawyer and a document preparer.
Well, yeah. So, yeah, I mean, especially when we're dealing with real estate fraud. Yeah, and that's what it is, right? If you forge a deed and you go record it, that's real estate fraud. And that's criminal, in addition to civil.
Plus, I don't think the person that did it was a legal resident.
I see. Well, if he was still living here in Arizona, he'd still be subject to criminal prosecution. So
yeah.
Yeah. So that is yeah, and I didn't bring that up in one of my examples, but that is a way that this comes up, is in real estate fraud. And frankly, that's one of the things that is specifically contemplated under 33420, right? It says that the person, if they have reason to know that the document is forged, right, groundless, contains a material misstatement, or false claim. All right. Hey, Mary, yeah, go ahead.
So just to let you know, and you may know this, and I don't know if other counties are doing it, but Pinal County launched a new thing called title alerts, and you can sign up. So for Pinal County, you can sign up for an alert that will say if somebody is trying to record something against your property.
That's phenomenal.
And so I have to assume others. I have to say Pinal County has one of the best recorder departments. But if they want to do, I would just say they call it title alerts. And it's any kind of recording notification service started June 30th, 2021.
Wow.
So
that is great that they're doing that.
So what I'm going to do is go back to all my records. I'm going to do a kind of a form thing and send it within anybody I've done within the last year, and just send them a flyer and state, hey, go, if you want, go on to this. But also, I can't imagine that Maricopa County would not be doing that fairly soon.
I hope they do, because that is exactly what, more than any other thing, would cut down on the kind of real estate fraud that we have dealt with in our office in the past. I'll just give you a brief example. We had a client that came in. It was an elderly lady, and she had been living in this home for decades. She had long since paid off her mortgage and believed that she owned her property free and clear. And come to find out, her nephew forged a deed that purported to convey the property from this lady into a trust that was controlled by this nephew. The nephew then, once he was able to basically transfer this property, he then was able to go to a bunch of hard money lenders and borrow money against the property. And because he was able to create this trust that had a particular hierarchical structure in it, it looked sort of legitimate, like almost legitimate, to where he was acting as a power of attorney for his aunt, and so it was able to get past a hard money lender who is supposed to do due diligence to make sure they're lending to an appropriate party, and they actually loaned the guy money. And then once he got money from the first hard money lender, he then refinanced the money, that loan, with another hard money lender to get more money, and then refinanced a second time with a third hard money lender to get even more money. And it created this, because once the first one was done, then the next hard money lender assumed that the first hard money lender did it correctly. And so there were fewer questions asked. And then the third time, nobody was asking questions anymore. And the guy ended up borrowing $140,000 against his aunt's property, and then consequently either blew the money, hid it under his mattress, who knows. But by the time I got involved in the case, this guy was a degenerate. We ultimately got a hold of his bank account records. He was taking trips and buying cars for him and his son, and it was a complete nightmare that would have been prevented had she had a service like what you were just describing, Mary, because the only reason that she found out about this thing in the first place was that her niece, so the sister of the person who was the bad actor here, was helping her aunt and was paying her county taxes, and the tax person who at the counter was helping her with the payment said, "Hey, just so you know, there's you guys aren't the title, according to our records, you guys don't own the property anymore. Why? You're trying to pay. I just want you to know." And that's how they found out. But this guy had 9 months of time to do all of this before they ever found out. And if it wasn't for that lady who, frankly, went above and beyond what her job title was to let them know, it might have gone on for even longer. So, Mary, I'm really happy to hear that the counties are starting to do this.
Yeah, and I just posted on the chat thing the website to go on to do that for Pinell County.
That's
if you
great.
look at the messages, so anybody that wants to take a look at that.
That's great. Yeah,
Brian,
Brian,
I'm sorry to interrupt. I just want to make a little announcement. I am so sorry for those of you that have been stuck in the waiting room for a while. There's some problem with the system where starting a little bit after 8, I have been unable to see the waiting room. And so if you happen to accidentally drop out or get disconnected, please send me an email and then go back to the waiting room. If I type in your name, it'll come up and say you're in the waiting room, but I'm getting no notices that people are waiting. So I really apologize for those of you that were stuck. But yeah, please I'm monitoring my email now since I'm not presenting anymore, and I'll get you right back in.
Cool.
And Brian, you don't have any ideas about that, do you? I get
The only thing I can think of, because this was set up as a meeting as opposed to like a, I forget what Microsoft calls it, like a presentation, like a webinar.
Right.
The only reason I can think of is because of the amount of people that are in this meeting. I show 70 people. It could just be a hiccup in that, in the amount of people that this meeting currently has. So,
All right.
anyway.
Well, in any case, just let me know, email me if you get dropped out and I'll come right back. I'll get you right back in because I'll search for your name. Thank you. Sorry, Brian. Go ahead.
No problem at all. Okay, so that's subsection A. So this subsection just contemplates a person who is actually claiming an interest in real property, who knows or has reason to know that this interest or this document that's been recorded is forged, groundless, contains material in a statement of fact, or is otherwise invalid. So there's a couple of other scenarios that are contemplated here. The next one that is contemplated is under subsection C, and it says a person who is named in a document which purports to create an interest in or lien encumbrance against real property, who knows that the document is forged, groundless, contains, and it uses the same language as subsection A, is liable for treble the actual damages if he willfully refuses to release or correct such document of record within 20 days from the date of a written request from the owner or beneficial title holder of the real property. So how is this different? This is different, one, because it requires notice before you can sue this particular person. Two, it's different because it contemplates a person not who's actually claiming an interest, but who is simply named in the document. So that could be, arguably, the person at the top of the document who prepared it. It could be the person at the bottom of the document who signed it. It could be any number of people who are on that document, because all it says is a person who is named in a document. And hold on, let me just mute everybody here. Okay. So that is a significant difference here, and really implicates also those of you who are preparing deeds and other encumbrances that affect real property. It is possible that by doing so, again, the bar is high, but I'm not talking about whether you would ultimately become liable. I'm just saying the possibility that you, as a preparer of legal documents, may get roped into litigation, even if you as the preparer may have no reason to believe that the document is groundless, forged, or contains a material misstatement. The fact that you're simply named on a document under subsection C of 33-420 means you could be pulled into litigation. Someone will make an allegation against you that you knew, right? And you'll be forced to defend yourself. And obviously, for those of you who are here and listening, I have no reason to believe that any of you would knowingly create a document that is forged, groundless, or contains a material misstatement or a false claim. But I think it's very interesting that Arizona has decided to give this kind of cause of action against people. And so what's good is you will, in order to be pulled into litigation, you would have to have received notice in the form of a letter saying, hey, we believe this is wrong. You need to correct the record here. And so just be wary of that, and the fact that is out there. And so that is subsection C. So let's move on here. I'm moving back to subsection B. So we covered subsection A, subsection C. Now we're going back to subsection B because this is what actually provides the remedy. What it says is the owner or beneficial title holder of real property may bring an action pursuant to this section in the Superior Court of the county in which the real property is located for such relief as is required to immediately clear title to the real property as provided for in the rules of procedure for special actions. Okay, let's talk about what that means briefly. What that means is when you go and normally file a lawsuit for damages, for breach of contract, or whatever the case may be, right? You probably know that the process for litigation can be incredibly long. right? And so it could be years in order to get a final judgment in a civil case. Well, Arizona knows that that's not okay when we're dealing with liens against real property. And so what it basically does is it provides a shortcut. It says if you are dealing with one of these issues that's highlighted in subsection A or subsection C, you can bring an action under the procedure for special actions, which basically is the fast lane to getting some sort of a judgment and relief to clear the title to real property. And so, and so what it says here in paragraph 2, it says a special action may be brought based on the ground that the lien is forged, groundless, contains a material misstatement or false claim, or is otherwise invalid. The owner or beneficial title holder may bring a separate special action to clear title as to real property, or join such action with an action for damages as described in this section. In either case, the owner or beneficial title holder may recover reasonable attorney's fees and costs in the action if he prevails. So what that basically means is you've got two remedies here under this statute. You've got the remedy of clearing the title so that you can sell it. That can be brought under the special action, which is the fast way to go to immediately clear title to real property. You also have your action for damages, right? Your treble damages that you can collect if you win. What this is saying here is that doesn't fall under the special action procedures. You don't get your damages immediately. That will have to take the normal course of litigation. So you can clear title immediately, and then the only thing that would be left is, are you entitled to damages? And that will then proceed as a normal real estate action in litigation would proceed. Is basically what it says. But what's great is if you're trying to sell your property and you've got this lien out there that you know is groundless or forged, you as a property owner have the ability to bring a special action to clear that like immediately, like within 30 days, which, you know, in the court system is essentially immediately. And so that is a great way to get some relief. All right, let's go quickly to subsection D, a document purporting to create an interest in or lien against real property not authorized by the statute. So if the deed falls under one of these, you know, forged, groundless, contains material misstatement, what it says is it is presumed judgment or other specific legal authority is presumed to be groundless and invalid. So it's simply stating that that document, once it's determined to have fallen under this statute, is presumed to be groundless and invalid. And then finally, subsection E, it says a person this is the criminal portion of the statute. It says a person purporting to claim an interest in, and again, it's using the same language we had before, forged, groundless, containing material misstatement. That person who records that deed is guilty of a class 1 misdemeanor. So not only do you have a civil action against this person, but you can file a criminal complaint against them as well. And they can be prosecuted under a class 1 misdemeanor, which hypothetically could carry some sort of jail term for them. Although as a class 1 misdemeanor, I imagine that it rarely results in jail time, probably a fine and something on your record. So okay, so I know we spent a lot of time here, mainly because this is more than any other action that we do in our office. This is where we live. ARS 33-420, ARS 12-1103, adverse claims, slander of title against real property. And so I hope that as we've gone through here on this particular section, it helps you think of issues that may come up as you are interacting with your clients. And if you ever have a question about these statutes or you run into an issue where you think this statute may be implicated, I always say just contact me. Drop me an email, give me a phone, give me a ring. I'm always happy to jump on a 5-10 minute conversation with a legal document prepared to sort of talk through that issue. And if it's something that I can help you fix with your client, great. or if I need to meet with your client and help them get legal advice before they continue with you, I'm always happy to do all of that. So, all right, let's move on to partition. This is something I imagine probably comes up for those of you who are doing who do like dissolutions, who do probate work. Partition can come up fairly frequently, and so so I may not be going over anything terribly new for those of you who are in those areas, but let's talk about what partition is. We're in ARS 1211A is the statute, and it says the owner or claimant of real property or any interest therein may compel a partition of the property between him and other owners or claimants by filing a complaint in the Superior Court of the county in which the property or portion thereof is situated. All right, so what is that in English? What that in English is when you have two people who own a property, two or more people who own a property, and one of those people wants to be able to sell the property, and the other person doesn't want to sell the property, this is how we deal with it, right? And there's only two ways that you can deal with it. When you have one person who wants to sell a property and one or more people who don't want to sell a property, there's really only two ways. Either one, you can divide the property so that each person gets a portion of the property based on their interest, or you can sell the property and divide up the proceeds the same way, right? Those are the only two outcomes. And in Arizona and in most of the country, this is an available remedy. Why? Why can you force the sale or partition of a property? Well, because in America, property rights are one of the most important rights that we protect. And one of those rights, one of those property rights that you have as an owner of land, even if it's a portion of that land, is the ability to sell that property. You unless you have a very specific circumstance, you should always, if you own land, you should always be able to sell it. And so this statute, it gives sort of the instructions on how to go about selling your property if you own it with other people and there's a dispute over whether it should be sold. So how do we go about that? So if we're in subsection B here, one of the ways to do that is to bring an action in Superior Court. In fact, this is really the most common way to do it, is bring an action in Superior Court, and you'll be filing a complaint. And what the complaint will state is the names of the people, the names of the property at issue, what are the relative interests of the parties, meaning if you've got a deed, right, that deeds the property to John and Jane Doe Smith, right? The presumption will be that because it names two people, they own the property 50-50, right? But that may not always be the case, right? You can, in a deed, specify that you are deeding of the 100% interest, you're deeding 25% to this person and 75% to this person. So in the complaint, you'll have to list out what are the relative interests of the parties who own the property and a description of the property so that it can be identified. So that is essentially what's covered in subsection B. We jump down to ARS 12-12-15. And it talks about the appointment of commissioners. So it says a court shall enter a judgment directing that a partition of the real property be made in accordance with the shares and interests of the parties entitled thereto and specifying the share and interest of each party. The court shall appoint 3 or more disinterested persons, commissioners, to make the partition in accordance with the judgment. The clerk of the court shall forthwith notify the commissioners of their appointment, blah, 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 blah. The court may also appoint a surveyor to assist. Okay, so this is for the scenario where you have land that has the ability to be physically partitioned. And what happens is you've got 3 commissioners, generally they're real estate agents who are licensed and who are qualified by the court to be able to do this kind of work. And you get a surveyor and you go out, let's say you have 2 people, they're going to go out and they're going to try to, with the surveyor, divide up the land so that it is as close to, in this case, 50-50 as possible. This basically never happens in places like Maricopa County, right? Why? Why would that not happen in Maricopa County? Well, the reason is because in Maricopa County, almost every property that people own out there has, and we're just using consumers out there, it's got a single family home on the property, right? You're never going to be able to physically partition a property that has a home on it into 2 or more pieces and have it be an equal division of the property, right? And so this portion of the statute really only deals with when you're partitioning land, right? I'm sure there are plenty of scenarios in Arizona where this is the way that the process plays out. But I will say, at least for my practice, I've never had to go down this road because it's just so much more rare compared to this other scenario that we'll be talking about in just a moment. But it's good to be aware of it, that basically the court will appoint 3 commissioners who all will have to agree together and make a recommendation to the court based on a survey that's done to divide up a piece of land. That's the process there. And then if we jump down to 1218, incapable of fair division, you'll see at the top there. And what it says is, if the commissioners are of the opinion that a fair and equitable division of the property or any part thereof cannot be made, they shall report such opinion to the court, and blah, blah, blah. And then the court shall order a sale of the property which is incapable of partition. And I'll leave you with that. I'm going to give Dawn a copy of all my slides so that I don't have to read everything and you can go back in your own time. But basically the way that this plays out is, and the way that we do it in our office, and that I would recommend you do if it's something that you're going to be taking on as part of your practice, is you simply file your complaint and you make an allegation in the complaint that the property cannot be fairly divided physically. And you just allege it in your complaint. And most people in a dispute like that are going to agree, yeah, of course, it can't be partitioned. And so the court, instead of appointing the 3 commissioners and getting a surveyor and all of that, none of that happens. Instead, you just appoint the commissioner, 1, and they just sell the property. And so it becomes a lot more straightforward. So in any event, so that's that. Dawn, I don't know how I want to be respectful, obviously, of everybody's time. I'm at 10. Obviously, I got started a little bit before them, but I don't want to shortchange anybody else. So you tell me how you'd like to do this.
I think you're fine finishing up. Kelly, are you good with that?
Absolutely.
Okay.
Great. And here's what I'll do. I think forfeiture is a really interesting topic, and so I'll cover that really briefly, and then if anybody has questions about some of the other issues, the eviction and lien foreclosure, just get with me offline. I'm happy to sort of chat with you about those. But you'll have my slides, so you'll be able to see those and so anyway. All right. Well, let's move on briefly to forfeiture. The reason why I want to bring this up, because I think it's sort of I don't know that it's unique to Arizona, but it's another thing that does not exist in Georgia, where I also have a practice. And so I don't know how unique Arizona is, but it's a really interesting remedy. So in Arizona recognizes 2 broad ways to finance or sell your property where there's debt involved, right? The first one is the conventional way that everybody understands, and that is you go get a loan, right? And the lender will have a security interest via a deed of trust, right? So a deed of trust is recorded against the property, and then you have a promissory note as the buyer. You have a promissory note with that lender, so that if you breach the promissory note, then the lender can go in and foreclose on their deed of trust and have the property sold to get the loan paid off, right? Everybody should understand how that typically works. Well, the other way that Arizona recognizes to sell the property, and this is used in cases where there is where the seller is doing owner financing, right, is instead of immediately conveying the property to your buyer, instead you enter into an agreement for sale. And my guess is there's a lot of people in this group who are familiar with this, but for those of you who are not, instead of entering into a purchase contract where someone goes and gets independent financing, or even finances the sale with the seller themselves through carryback, the other option is, okay, instead of me getting title right away, I am going to enter into this agreement with you where I get to go into the property immediately, but the title will stay in the seller's name until such time as I pay you what the agreed amount is. That is essentially what an agreement for sale does. It says, I as the seller and you as the buyer are agreeing to the sale of this property. You will pay me X number of dollars over this amount of time, and at the end of it, I am obligated to then pay your, finalize the sale by giving you a deed to the property, right? The benefit to this, if you're a seller and you're like, do I just, do I want to do a conventional loan? Do I want, or do I want to do this like sort of weird agreement for sale? There's a huge benefit to doing an agreement for sale. And that's where forfeiture comes in. So let's talk about what this is. Forfeiture is great. And has some and here's why. So forfeiture is not the same as foreclosure. Forfeiture involves a purchaser's interest under a contract for the conveyance of real property, and the timeline for forfeiture will depend on an amount of equity the purchaser has in the real property, and it can be done judicially or non-judicially. Okay, so what forfeiture does is allows you as the seller who's selling to a buyer to actually forfeit the interest if there's a breach. So if you are a lender and you have a deed of trust, what is your remedy? Your remedy is to sell the property and collect whatever the balance is that's owed on the loan, right? Well, forfeiture works differently. Forfeiture, if there's a breach, you've been paid presumably a certain amount of money under the contract. And if you forfeit the purchaser's interest, not only do you get the property back, but you end up being able to keep all the money that's been paid under that agreement to that date. So you may end up actually having a bit of an enrichment that occurs. And the law rarely provides for an enrichment like that, where not only do you get the property back, but you actually get to keep all the money that's been paid. Under a conventional loan, you don't get that. You only get the balance of what's owed, right? You're just made whole. But under a forfeiture, you get more. And so how does that work? Well, there's a series of notices that need to be sent out. And there's a process, judicially and non-judicially, that you can go through. And without getting into the weeds, here's essentially what happens. The notice that has to be provided, the notice of breach, there has to be an opportunity to cure. So the person who is in breach has to be provided with the ability to get current. And the amount of time they have to get current is based on how much they've paid. So if they've paid less than 20% of the total purchase price, the notice they get is 30 days. But if they've paid between 20 and 30%, they get 60 days. And if they've paid more than 30%, but less than 50%, they get 120 days. And finally, if they've paid more than half of that property off, they get 9 months to be able to get current. But if you play that out and the person who is in breach doesn't get current and you are able to finalize that forfeiture, you are able to keep all that amount and you regain possession of the property. And that's done in two ways. Judicially, you can file a lawsuit to have the court enter an order determining that that property is now yours again. Or if you have engaged a servicing agent during at the outset. So if you set this up where you're like, hey, you as the buyer, you just pay this third party, and the third party will then pay me the money. Sort of like it looks like a normal loan type situation. If you've done that, you can do it non-judicially, where the account servicing agent that's been servicing this loan for you can basically send out the notices, and you don't even need to get a court involved. They'll get the notices, you'll record the various notices and the fact that forfeiture has been finalized, and you're done. At that point, you go and evict the person. So in any event, it's a very powerful tool that some people are using, but many people don't, in order to hedge against potential breaches of a sale of real property. And so that's why a lot of people use it. Like, hey, look, frankly, if I think there's a risk that this person's not going to go through with it, why not do it this way? Because I'll take whatever money they do pay me, and then I'll just get the property back at some point in the future. So anyway, so that's something that people will do, and it's a completely valid remedy. So okay, I appreciate the extra time. I'm going to call it there. If there's any last minute questions, obviously, Don, I'll sort of defer to you since I'm over a little bit, but
Okay.
But that'll
All
be
right.
the content I have for today.
All right, Brian, thank you so much. We really appreciate you, and I really encourage everybody to utilize Brian's willingness to answer questions, to help out. And I know other people in his law firm are also very open and willing to help out legal document preparers if they have questions, or if they just have something that they don't feel like they can handle. So we always appreciate Brian, and I expect some other people from your firm will maybe help out for some of the remaining classes this year on some other topics. So thank you so much, Brian. I appreciate it, and so we'll move on to the next presentation. I do want to make a little announcement too, that the waiting room, it seems to be working now. So I don't think it's anything I did. I think there was something in the system, the Microsoft Teams system online, that was screwed up, and it's just started working again about 15 minutes ago. So in any case, but still, if you do get dropped out, just to play it safe, do send me an email so I can make sure that you get immediately back in. All right, so we are going to move on in just a minute to our next presentation. I do want to, I'm going to hold up actually two words. I'm going to go back. This is the word that I last gave the first magic word for the webinar. I want to hold it up again just in case a couple of you were locked out at the time I held it up. So it is watch, WATCH. Again, you want to write down the 3 words throughout the day to make sure so you can email those to me to get your certificate of completion. And then I'm going to also hold up the well, I'll do the second one about partway through Kelly's presentation, but I wanted to hold that up again. So let me get Kelly all set up, and then we will move on. Okay, and Brian, I think, put his contact information in the chat just now. So Kelly, let me spotlight you so you can get going. Okay. All right. So our next speaker is Kelly DiCarlo. Kelly is going to give us a presentation about family law update. As I mentioned at the beginning, She's going to talk about just updates and new family court rules and statutes, which there have been several significant updates that she'll talk about. And that's going to include a discussion about terminations of legal separations, the summary consent decree process, changes to Rule 14, information on the proposal for spousal maintenance guideline changes. And so let's all welcome Kelly. Take it away, Kelly.
Good morning. Can you see the screen and hear me okay?
Yes.
Okay, great. All right. So there's been a lot of updates to our statutes and our rules. A lot, and this all relates pretty much to family law. And I'm going to go over those processes, or most of them. One of the major ones is the summary consent decree process. I don't know how many doc preps are using this yet. I know some are, and this is like an amazing process that our presiding judge of family court, Judge Cohen, came up with in about 2019 and started it in Maricopa County before the statute went into place in September of last year. I think it's a great process. It rewards the parties that are working together and not taking up so much of the court's resources. It also streamlines the process, and it's something that not only the parties really like, it's also something that paralegals and doc preps do as well. It really reduces a lot of the work that you have to do. Judge Cohen is also the one that proposed the statute that eventually our legislation granted, and it became a statute. And also with the statute came the court rule to accommodate it. Let me get back here. And so the statute is ARS 25314.01, and the court rule for Arizona Family Law Rules procedures, that's Rule 45.1. So I'm going to go over both of those and add to them because I think it's important to understand the statute and the rule to make sure that you're preparing the documents properly, and also to understand exactly everything that's involved. There is court forms. I know they are in Maricopa County. They've been there for quite some time. Also, Pima County has them. I don't know about the other counties. I haven't looked yet. I'm sure they do, or I think they do. And if anyone knows different, please, chime in. So one of the things, the thing about streamlining the process is there's not all these different steps that you're doing, and it reduces the amount of calendaring you have to do. In fact, you don't even really have to calendar, depending on how you're keeping track of all your summary consent decrees. Service is waived. Yes?
Kelly, I'm so sorry to interrupt, but I don't think we're getting, I can see your first page of your presentation, but it doesn't seem to be clicking through. Is it shared? Full
It says that it is presenting.
Okay.
So
I'm
what do you
not
see,
like
the first page?
I see, yeah, just the first page that just says family.
Paused, and you will need to go back to the window you were sharing to resume. I'm sorry, I apologize. Hold on.
It's okay.
I didn't realize.
She's got a Mac, for those of you giving suggestions, just so you know.
I can't seem to get out of the screen. Oh. Let's try this.
Okay, yeah, now we can see the summary consent petition and decree is what's on the screen.
Okay, let me start from here.
All right.
Can you?
Yep, that's full screen now. Now we can see it a little bit better. Thank you.
Okay, I'm getting that same message though. Sharing is paused. Can you see the next screen?
I'm seeing summary consent decree process.
Okay, so there is some kind of issue here. All right, well, let's try something else here.
Okay. If you can't share the full screen, but like right now we're seeing.
Do it from this screen. It's not the screen I prefer, but at least you guys can see it, right?
We can see it. Yeah, we can see you clicking through the. Yeah. So it says summary consent decree process right now.
Right, and this is the statute and the rule I was referring to. And I was also saying that the process itself, some of the things that I really like about it, and so do other paralegals and doc preps and parties as well. One of the big ones is there's no summons involved, and it waives service. And this can be a major time case saver in many cases. Even in cases that we have where parties agree, it can take weeks for the other party sometimes to sign the acceptance of service. So it's a real streamline to the process. It's also rewarding parties that are working together. Let's see. The first part of the statute, and then we'll go over the rule next. If the parties reach, the main thing that's required is that the parties reach an agreement on all the issues before either party initiates the formal dissolution of marriage or legal separation proceedings. So they have, if that is the case, they have the option to elect this process. Currently, one of the things I'm not clear on is the forms for Maricopa County specifically state that if you have a covenant marriage, you can't proceed with this process. Yet the rule and the statute mention nothing about a covenant marriage. And covenant marriages, my understanding throughout the years is that if both parties agree to divorce, they can with a covenant marriage. So I'm not sure why that information's out there. And I'm going to try to look into it further when I have some time. But basically, the parties need to be in complete agreement, and they need to be willing to sign off on all the documents together. Sometimes the parties are in agreement, but the other party might not want to sign off on documents. So I try to make sure that's all there before we proceed. And also, I prefer to have both parties part of the meeting when you're doing the intake to get all the information, especially when children are involved, because you have to go through all the details from the beginning. With children, the parenting plan, holiday schedule, school breaks, vacations, all that stuff, and a calculation of child support. Whereas when you're doing the regular process, you don't have to do all that stuff. You can just initiate the case. And then, if the parties are there, even if there's something they disagree on, a lot of times they can work it out while we're taking the information. And then occasionally I do some of them with only the petitioner. And I haven't really had any issues yet, but I can, it's just one of those things that it's probably better that you make sure you have everybody on the same page. So when it comes to the signing, you're not having a problem at that time or having to make a lot of changes at that time. One of the things that's part of this process is the parties filing a combined petition and response. So there's no longer, just a petition and then later the other party responds, or you go straight to the consent decree. They actually have a combined petition and response, and I'll go over that in just a little bit. And that's pursuant to section 25-314. The petition shall state the formal service of process is waived. Again, this is one of my favorite parts, and that all issues are resolved by agreement. This is the same language that's always been required in consent decrees that I usually put in the beginning, towards the beginning of my consent decrees. The next part on here, the filing fee. This is how the statute reads on the filing fee, and I was really excited about this part as well because it decreases the combination of the two filing fees. And the statute specifically states that it's 50% of the combined filing fees for the petition and the response together with any, but each county can add fees to it. I was a little surprised at Maricopa's, it's $426.50 as opposed to $349 and $274. But they actually added quite a bit to it, more than I expected. I'm sure they have their reasons, but I was hoping it was going to be a little less than that. But it still hasn't deterred people from doing the process most of the time. So basically, it's just taking the two filing fees, combining them together, splitting them in half, and then the county can add whatever they want to it. So again, in Maricopa counties, that's $246.50. So if you look at the filing fees in the different counties, they should have a filing fee listed specifically for summary consent decree process. At the time of filing the petition and the response and all the other documents that go with it, this is when the 60-day waiting period starts. And this is something that's very different as well, because it's always been, it starts from the date of service. And so the date of filing is what starts the 60 days. And again, big time saver with that waiving service and not having service delay when the 60 days is starting. And what this particular section of the statute is talking about is that before the 60, once you file and submit. Some people file and submit, and the rule and statute allows you to file the initial documents and within the 60 days submit the documents, which is what the statute's about, that finalize the case. And this particular process I haven't done yet. I'm doing everything at one time. We file and submit everything at one time, but I'm considering offering this as an option because it may speed up getting the documents filed, because when you're doing the documents that are going to be filed and the documents are going to be submitted, your consent decree, or with children, consent decree, parenting plan, child support worksheet, child support order, it takes longer to prepare all that stuff. And I'll touch on that a little bit more too. So this 60-day waiting period, it starts from filing, and if there are children involved, there is an extra step. Even if you file and submit everything at one time, the parties still have to take their parenting class. And I do monitor that, remind the clients, and I know that some judicial assistants are also emailing the parties, letting them know that if they don't have their parenting class done by the 60 days, it'll be, rejected. So the parenting class is something to look out for, to make sure that's completed prior to. I send out emails to remind them or call them, and just to remind them to get that taken care of so they don't have any issues with getting the consent decree to go through. It also, the next part of the statute just says that the court may not enter the final decree earlier than the 60 days, and that's pursuant to the statute 25-329. This is something that I really clarify with the parties. And I know that it's something that's had to be clarified in the past, but for some reason with this process, I seem to encounter it more, where people will email me or call me and they think their divorce is done on the 60 days. I make it clear that this is the 60-day waiting period. Once that passes is when the judge, once they have the time to do it, reviews and finalizes, signs and enter the documents so they're final. So that's something you may want to clarify with the parties, because a lot of people assume the judge is just going to sign off right from there. The next part of the statute is, this is the part that the parties have the right to withdraw from the summary consent decree process before the 60 days expires. I haven't seen this yet. I know there is a court form for it. Haven't experienced it yet, but they can do this. I have had at least one client that was very nervous about this because they were afraid the party was, and we ended up doing a Rule 69 agreement just to try to help keep it in place better, their agreements at least, and that one has actually just gone through or about to. But so either party, and this is contained within the summary consent decree documents, it's also in the statute and the rules. And then there's an information sheet you get after you file that lets the parties know this as well, that they have the right to withdraw from this process before the 60 days. And if they do, they just need to submit a notice of intent to withdraw from the summary consent decree process. And that is considered a withdrawal in accordance with the family law procedure. I haven't had this is such a new process with the statute. I haven't seen that happen yet. If any of you have, please share. But the only thing I'm not sure about, because I haven't experienced it yet, is if someone withdraws from this process, what happens with service? Do you have to go back and serve? How does that work? Or is that already considered done because it was waived? That's what I'm not quite clear on. If both parties decide that they don't want to continue with the process, they can jointly withdraw from the summary consent decree process, and the court will dismiss the case. Rule 45.1 is the rule created to go with the statute. And we'll go through that one as well. And all the documents that I have here, they've been provided to Don, and he can provide them to you as well. This is the rule. It says that it's very similar to the statute, but basically if the parties reach a comprehensive settlement on all issues before either party has petitioned for dissolution of marriage or legal separation, they may file the summary consent decree petition in response and pay the appropriate fees. It does say that this rule does not apply to petitions in paternity, maternity, or third-party matters. So only legal decision makings, currently only dissolutions and legal separations. The next part of the rule breaks down what must be in the document for the petition and the response. So I don't have to read it all out to you, but it's pretty basic information that needs to be in there that we pretty much include anyway. They do say the statement of grounds for the court's jurisdiction, which is the 90, one of the parties been here 90 days or more for subject matter jurisdiction, or if children are involved, that the court has jurisdiction to decide legal decision-making and parenting time, which is typically 6 months or more living in Arizona. There is a statement that formal service of process is waived. And then the pretty standard language about the marriage being irretrievably broken, or that the parties desire to live separate and apart if it's a legal separation. That the parties have resolved all their issues about their dissolution or separation. And the request of the court enter a decree of dissolution. And I'll go over those documents here in just a little bit. And of course, both parties sign this document. The preliminary injunction is still required. The only thing that's really not part of the documents that go with it is the summons. So you still have a preliminary injunction, notice regarding health insurance if it's a divorce, and a notice regarding creditors. The entry of the summary consent decree, this again is where the rule states that you can submit the final documents after you file the summary consent petition and response. I don't know how the other doc preps are doing it. If you want to share, please do. But currently we are filing and submitting everything at the same time. But like I said before, I think it could be beneficial to expedite the case and maybe even possibly give you more control over the final documents. Let's see. I had made some notes on this somewhere. Because again, it could speed up the process. But I have I think I wrote it on the consent decree that I have as part of the documents that I was going to go over, of some of just my thoughts on the benefits of, filing and later submitting the documents, or filing and submitting everything at one time. Again, we have the waiting period here of the 60 days. That has not changed. I don't think it's going to change anytime in the near future. But again, starts from filing instead of the date of service. One of the things I try to do during the 60-day waiting period is just touch base with the judicial assistant to make sure they have the documents. The process when we file is we're filing over the counter the documents that initiate the case, and we'll go through that. And then we're also submitting the final documents. And that once it's filed, it goes to family court admin, and then they are the ones that provide it to the assigned judge's office. In the last 3 months, we had a lot of judge changes, and I would say probably a quarter of our summary consent decree processes or process cases, the judge changed, and I was definitely contacting those offices to make sure. One of them actually had to go track down the consent decree instead of, believing later they just didn't receive it. So it was helpful in that way. And let's see. It does say that the court may set a hearing on this. That's always been the case for a consent decree, but over the years, 99.98% of the time, I haven't seen a hearing. It's been very rare that I've seen a hearing set, and usually reasonably so. It makes sense when a hearing is set on this, but the court does have the right to set a hearing if it does, if that's what the court desires to do. Otherwise, it's just like the consent decree process typically, where they just, review, sign, get it filed, and then the copies go out to the parties.
Kelly, I have a question.
Sure.
I have a question. And I apologize if you already commented on this, but I would assume that the parties can make any changes they wanted to in the final decree that's submitted, because they're both signing it, correct?
You mean like if it was filed and the document submitted and during the 60 days they wanted to make a change?
Yeah.
Yeah, absolutely. I mean, I
Okay.
haven't had that happen yet, but I don't see any reason why it couldn't. Yeah, I definitely think so. And probably some of the people that are, attending have had that situation happen, but I see no reason why it wouldn't. I mean, there might be a motion or something you need to file with it. I would determine that once I was in a situation like that, but I see no reason why they can't do that. Okay. Again, they talk about the notice of intent to withdraw. This is very clear throughout everything in the documents and the rule, the statute, that the parties have the right to withdraw from the process during it. And then here's a list of documents, primarily the documents that are included for the documents for a summary consent decree without children. Currently, I don't know any different, and the forms lead you in Maricopa County that you need to believe that you need a sensitive data sheet for both parties. I don't know why that's necessary and why they can't do one together, because it's exact same information, and basically you just have the same document. One's called the petitioners, one's called the respondent. And I don't know if that's something we actually have to do, or if it's something maybe later they might consolidate it where the sensitive data sheet is for both parties. The notice of filing the summary consent decree process. This is the notice. It's a very simple document that I title it Notice of Intent to File Summary Consent Decree Process for Dissolution of Non-Covenant Marriage with Children or Without Children, and basically just states the parties' names and that they hereby notify the court they intend to proceed with the summary consent decree process, and both parties sign it. The preliminary injunction and the notices, I'm sure you're familiar with those if you're doing family law documents. Again, the only thing that's not included in there is the summons for those types of documents. Then you have a petition and a response. And the petition and the response is, mentioned in the rule and also the statute. And basically, it's a petition and response for the dissolution of a non-covenant marriage with minor children or without minor children. And it, states the party's information pursuant to the rule. Who they're employed with. It also states how long they've been domiciled in Arizona, the 90-day requirement for at least one of the parties. This contains the party's marriage date, where they were married. So far, our understanding of it is, not to do it for covenant marriages. So it'll state that the marriage is not a covenant marriage, which is included in the documents anyway. Have I been pushed out, Don? Is the screen full?
Your screen just disappeared.
Sharing has ended. All right, let me try again. Is it back?
Not yet. No.
Okay, looks like it just stopped. Let me try reopening it again.
Okay. Let me make sure. Yep, it's back.
Awesome. Okay. Like the thing for the covenant marriage has always been in petitions and decrees as well. So there's some pretty standard language in here. Also, that the marriage is irretrievably broken, or in a legal separation that the parties desire to live separate and apart. The conciliation provisions are mentioned here. I put in a sentence that says mother and father are not aware of any proceeding which could affect the current proceeding. That's just mainly so I have the client signing off on something, or the party signing off on something. So there's not a case somewhere else that, we're not aware of. Then whether the mother or the wife is pregnant, and then the court has jurisdiction for if children are involved to determine physical custody, legal decision-making for the minor children common to the parties. We also talk about the domestic violence, whether it has or has not occurred. That the parties have children, and then the statements regarding the children as far as where they have resided, for jurisdiction, the court to know they have jurisdiction, that there's no other cases in another state or county, and that the parties are not aware of any other person who are claiming to have any type of legal decision-making or parenting time rights or visitation rights with the children. And then it has a statements and waivers. The parties make the following statements and waivers. And its formal service of process is waived and all issues resolved by agreement pursuant to the statute 25-314.01. that the parties waive conciliation court provision pursuant to the statute 25381.01, and that the parties hereby waive the right to default pursuant to Rule 44, the Arizona Rules of Family Law Procedure. And then by signing and filing this petition in response, respondent in this matter would be husband, father, mother, wife, voluntarily appears in the matter, and no summons will be issued or served. And then it says that the voluntary appearance has the same effect as if a summons had been issued and served pursuant to Rule 40. Should either party no longer wish to enter into the consent decree, they have the right to file a notice to withdraw, which that's what's mentioned several, in the statute and the rules. And then there's a section, paragraph on the written agreement, and that the parties have reached an agreement that include spousal maintenance, the division of property and debt, with children, where the children will live, legal decision-making, parenting time, child support, and that the parties' consent decree, if without children, with children, the parties' consent decree, parenting plan, child support worksheet, and child support order are attached, or I put submitted concurrently herewith, because we don't usually attach ours, we just leave it separate. And then the last paragraph just says that the parties jointly request that the court issue orders for the following: dissolve our marriage and return each party to a status of single person. And then to enter orders as detailed on the attached and submitted consent decree, and with children, parenting plan, child support worksheet, and child support order. And then there's a list of the things, they're pretty basic, like restoration of name, sometimes paternity, sometimes non-paternity, orders regarding the minor children, child support, spousal maintenance, community property, community debts, separate debts, and filing state and federal taxes. And then both parties sign this form as well. If the case involves children, then you have to make sure you still have the order to attend the parenting class. I do let the parties know not to take the parenting class prior to this, so they have to wait until they have their case number. And then when I do send the documents to them after they've been filed with the court is when I provide the case number and the link for them to take the parenting class. And then I track whether they're taking the parenting class or not. So that's required. So these documents are the ones that initiate the case. And then the documents that complete the case are the standard ones and agreements that typically do. You have a consent decree of dissolution. It's primarily the same. Some of the language that is different is under the findings. I have in mind that the 60 days have passed since whichever party has voluntarily appeared in the case, when the parties filed the documents for the summary consent decree process, which initiated the 60-day waiting period. That's one of the things that are different in my in the findings in our template. And then the rest, a lot of it's pretty much it's really the same. One other thing that's a little different is when it talks about severing the parties' community interest. If the parties are going from the date of filing instead of a date of separation for the division of debt in property, I put in there any debt acquired or any property acquired from the date of the filing when the respondent voluntarily appeared in the matter. And then the rest of it is the same. And then you have, of course, the parenting plan, the child support worksheet, and the child support order. No need to go over those because it's still those are all the same as when we submit like a consent decree. Like I said before, I do sometimes include, well, at least one time so far, and it'll probably happen again in the future, a Rule 69 agreement. It looks like I got kicked out again.
Yeah. We also have, I think, a question for you. Linda Seeger was asking, are both parties your client? Seems that could be a conflict.
I was going to bring that up, and I was actually curious to get some input from other doc preps on this. And Dawn, yours as well. So we've always had, like, we do similar to what attorneys do. Is this back on you, Dawn?
I'm seeing your home page now, your desktop.
Okay.
Now I see it. Yeah.
So, you've always had one of the parties hire you to either initiate the case, or respond to a case, or, help them in some other way. But on the summary consent decree process, I've been thinking back and forth on this because you're really helping both parties. So when you're looking at a potential conflict, and I'm curious to see what you think about this, Dawn, how would you view something like that if you're working with both parties, they do a summary consent decree process? I still have whoever the petitioner is the client. But I've thought about this a lot. So you're helping both parties. They're both signing off on all the documents, and you're just doing the document preparation for this process. Is there a conflict if the respondent in the case comes back later and wants you to do work for them? Whether it's, I would think that it would be, prudent not to do something like that with maybe even both parties if they were working together and now they have some kind of, conflict. There's an enforcement or a modification or something.
Yeah, I have a couple comments on this, and I know a couple people have their hands up. But first of all, yeah, I think reasonable minds can differ on that issue as to whether or not you can help one party in the future with like a modification or something like that. But as it relates to helping both clients, while I'm not saying you have to do this, really, in the past, I don't do them anymore, but in the past, whenever I did consent decrees, I had created a kind of a notice of non-client, that I would have, one of the parties sign, just to make it clear that, one of these people was my client and the other was not. And I don't see why that couldn't be done, even though this is a summary consent decree process. You can still have an identified customer. And
I do right now.
Okay, yeah. And then, the other thing I was going to suggest, and I've always done this, but I always have for not just family law, but anything that I used to do, have a document approval and form that you should have customers sign after they've reviewed the documents. And I think in particular, dealing with this kind of a process with a consent decree, it's important to have both parties sign that. I have had a couple occasions, it's been many, many years, but where somebody would come back and say, hey, that's not what I agreed to after the consent decree has been entered. And so I mean, keeping copies of the documents, there are other things you should do, but having them sign a document approval is, acknowledging that they reviewed the documents, acknowledging that they reviewed the documents and approved the documents as they are, even if they differ from what was put into a questionnaire at an earlier point or in the original petition. If things have been changed, having them sign something like that, I think, can be very important. And so I want to read, and then we'll go to Rob. Let me read a couple comments in the chat. Let's see. Okay, Barry Goldman mentioned that he wanted to mention, as a process server, service of the preliminary injunction must be made by personal service. Otherwise, it has no force and effect. I think that's a unique and interesting issue because yeah, even though they're waiving process, I don't know. It does the petition, and I'm not really personally familiar with this. Does the petition specifically say that they're waiving process of the preliminary injunction?
It does not, but the rule, and it may be in the statute as well, the
Or they're
preliminary
accepting
injunction,
service of the preliminary
notwithstanding the requirements of Rule 25A, when filing a summary consent decree petition in response, the parties must present 2 copies of the preliminary injunction to the clerk to issue under ARS 25-315A. The clerk will issue the injunctions and return copies to the parties. My understanding is it's just like when someone files a divorce, the preliminary injunction goes into place for them, and the other party, it doesn't go into place until they're served, but they're waiving service, and so therefore the preliminary injunction that's why they're talking about 2 copies, is going into effect for both parties upon the filing.
Okay. All right. And then Rob, you wanted to make some comments?
Yeah, just briefly, our policy in our office is I never let both parties come into the office for the initial intake. I've had some very bad experiences with that, where I, inevitably there's something I'll bring up in that questionnaire or in that process, that intake process, that they haven't thought of. And all of a sudden there's a giant argument going on in my office. And so I kind of eliminate that. I just say, look, one of you gets to choose which one of you is the client. You come in, we'll do the initial intake, we'll create the documents, we'll email them out to both of you. You guys can discuss off site any changes you want to make. We'll make those changes. And then if you want to come in and sign them, that's fine. But every issue in that document needs to be resolved prior to you coming in together to sign. And then we just have them sign a third party thing that says, hey, this is the client, this is the other party. That's about it. So we just, I don't know that it's better or worse than having 2 clients or not, but that's just our policy, is we just pick one person, and that person is the one we deal with.
Are you doing the summary consent decree process?
Yeah, I've done probably 7 or 8 of them. So
yeah, I don't know. I'm still just thinking about it. I haven't come to a full conclusion on it. And the thing about meeting with both parties, I mean, that's something we've done throughout the years, but I do it primarily by phone. And, in family law, you're going to encounter that eventually at some point. I mean, it just happens. And I have had one go south, and I just was quiet until it was over. But having them both on the same page, it can be efficient as well. And I don't encounter, like I said, it's only been one time, and I've probably done, dozens. I've done a lot. Like, I've probably done about 50 now, and I've only had one go south. And, we can have problems when someone comes in and signs an acceptance of service. We can have a big blowout right there, that's just part of family law. But I am finding it to help to be efficient, especially where children are involved, instead of having to go back and make a bunch of changes. And I know for sure they're on the same page, instead of doing the summary consent decree process and then having to back up because someone is not in agreement, and then back up and do the other documents for the regular process. That's what I've experienced.
Yeah, and generally how I work it is I tell them if they're going to do that summary consent decree process, I kind of give them a list and send them an email or give them a list of stuff. Hey, these are the things we're going to go over. You need to be aware of these. You need to be in agreement on these things before you come into the document, because if we have to go back and make tons of changes, we're going to charge you to do that. And so,
yeah, I do that in consultations.
I go through. So we make sure they just kind of have that expectation that they need to be in agreement prior to coming in. And then if there's little changes or things we need to make, that's fine. But,
sure,
we don't want material changes being made after the documents are ready to go.
Which can happen.
Right.
Yeah. Is there any other?
I am trying to get someone from the court to come into one of our trainings, hopefully before the end of this season, to talk about some whatever the good, the bad, and the ugly as it relates to these kind of issues, and how they're being processed through defaults or consent decrees. And hopefully maybe March or April, I'll have somebody come from the court to talk about that. I'm talking about the people at the court that process them.
So like the clerks?
Okay.
Yeah, that'd be great. When you do file the documents, file and submit, or just file and later submit, the court issues a receipt and notice, a summary consent decree. And on this receipt and notice, it's just a one page. It starts off with just stating that you're doing the summary consent decree process, what the case number is, and what judge has been assigned and who it'll be forwarded to. It also states what your 60-day waiting period, when it expires. And one of the things I wanted to bring up on this, and just real quick, the other parts of it is just, again, it tells you it does specifically right here that any changes to the settlement terms, you can do a joint motion to amend the decree. It gives you contact information, and it talks about reconciliation and the withdrawal from the agreement. But one of the things on this this document that comes out, we get it on top of the documents that have been filed with the court. So just the initial documents that initiate the case. And that's the documents that we have that we can scan and email to our clients. But one of the things I've noticed that could be a potential issue is a lot, I would say like 40% of the time the case number is wrong on this sheet. It's not wrong on the documents underneath it, it's wrong on this sheet. And where that could be a problem is if you're sending the documents to the parties and saying, okay, now you have to take the parenting class, here's the link, and they're entering in a case number that's not correct for this case, then you're getting it potentially filed in the wrong case, or they're having a problem. So I do keep an eye on that, and I point it out if it is the case and tell them to go buy the documents, not the notice. But that's something that I've actually seen quite often. Let's see. All right, let's run over that. And this is the notice I was talking about. I split it in half for the screen. This is the first part of it where you see the case number, what judge is assigned. And of course, the judge can change during the 60-day waiting period. It did a lot during the last few months. And then it has the 60-day, the expiration of the 60 days. And then this is the information provided. This is all on one sheet.
Hey, Kelly, if I
Yeah.
could, I just wanted to, in the chat, Susie commented that Yavapai County now has a family law navigator, and they look over the documents for your client prior to filing, or for those who aren't using an LDP.
Oh, good. I think I'd heard that, but I didn't know they would look over documents for a legal document preparer. I find I've done some work in Yavapai County. They're a very, very nice county to work in. Everyone is so polite and helpful. It's just, it's very refreshing. Okay, just some helpful tips, and I mentioned most of them. The 60-day waiting period, just clarify that with the parties, so later they're not sending you an email on Thanksgiving asking if their divorce is final. So they just have a realistic expectation about how that works. And I do tell them that, they do have to wait until the judge has the opportunity to review and sign. And most of the time I see judges sign off pretty quickly, but, they still have their 60 days from that point to do it. If children are involved, track and follow up with the parties on the parenting class. This could be a problem if they don't get it done. So I do keep track of that and send out emails and call them and stuff like that. So far, everyone has, taken their class when required. And following up with the judge's office, just depending on the situation. When I go over Rule 14, you'll see why I probably call the judge's office more than other people do. And that'll be explained later. Also, if there's a change in judge, that's a big one. It's just to make sure that everything's been transferred, that they do have the paperwork, because there was quite a bit of shuffling around with judges toward the end of the year. I also, once the case is complete, I do watch on the docket. If I haven't heard from the parties, I do email them to let them know the case is complete, and that if they have not already received their documents, they should be, and just ask if they need anything further to just kind of close things out. Okay.
Kelly, Linda had a question. Linda's practicing in Pinal County, I think primarily, or Pima, I'm sorry, Pima County.
Pima.
She says, other than a small difference in money and a tad quicker, she just wanted your take on why you may think that this process is better than just filing the petition and having the parties sign a consent decree.
Well, one thing is service is waived. That's a big one, because even when the parties agree, it can take weeks for the other party to sign their acceptance of service and get it back to us. or to come in and sign for it. That's one of the biggest ones. I'm also seeing these go quicker, getting approved quicker than I have consent decrees in the past. And I think it's because it's sitting in the judge's office. And I'm assuming they have it ready to go. So it can go in the judge's stack once the 60 days pass. Sometimes you're turning in your consent decree way after the 60 days, depending on what's going on with the parties. So it does keep everybody on track to get that done instead of it being, occasionally we have clients that are 4 months out, and they still haven't done what they need to do so we can complete the consent decree. The reduction in the court filing fee, especially when there's children involved, because most of those are uncontested divorces, are consents anyway, so it saves about $200. And what I like as a lot, the parties like having it all pretty much done. And, they just want to get this done and over with, which is a very common attitude. And, when people talk to you, I just want this done as soon as possible. I mean, yeah, you and everybody else. But they like that part of it. And on the side of, a paralegal or a doc prep, there's not you don't have to, it's not as much tracking and calendaring. So I'm finding it's saving me a lot of time as a document preparer.
Okay. Hey, Kelly, before you move on to the next topic, I want to go ahead and raise up the second magic word today, which is clip. CLIP, clip. So be sure and write the words down. This is the second of 3 words. And these are the words you're going to email me at the end of the conference so I can send you your certificate of completion. So that's the second word. All right. Thank you.
Do you want to take a break or anything? I wasn't sure if you wanted that.
No, I think we can just push on. Yeah.
Okay. The termination of legal separation that has the statute and the rule. This is another statute that Judge Cohen was behind, and he was coming in to provide a solution for a problem that probably most people weren't aware of. Prior to this statute going into place last year, I had done agreements to restore a marriage in a legal separation. And some of them went through, and then occasionally a judge would seem absolutely baffled by it. Like they didn't know what to do with it and would just reject it. Or I had one judge that eventually granted it and then went into all this detail with case law and everything. Well, come to find out, the issue was that there wasn't a statute. And that's why Judge Cohen was behind this statute to get it into place. So there is, a law and rule that is for the termination, and I think you'll understand more why as we go through it. The statute, the termination of legal separation decree, the statute and the rule, just like the summary consent decree process, are similar. The statute, which is section C of 25-313, says that any time after a final decree of legal separation that hasn't been converted to a decree of dissolution, the parties can stipulate to the termination of the decree of legal separation. The stipulated order shall be filed under the same case number as legal separation action and shall include the following. Just right here in the statute, they talk about stipulated order. In the rule, they start talking about a stipulation and order, and you can do it either way. I've only done one so far. I just followed the statute for the findings and the orders, and I did a stipulated order and did a notice of lodging, and it worked out just great. But there are times probably to consider doing the stipulation in a separate order separately in case maybe you have I don't know. It depends on who it's going to. It should be going to a judge. I don't want to go too much into that, but sometimes there are issues with stipulated orders. One of the ones that I've seen specifically is if you file a stipulated order, well, you don't file it, you file the notice of filing with a stipulated order, and it's over the counter, a lot of times the clerks don't seem to know what to do with it. And I believe that's because attorneys primarily do stipulated orders and they don't see them. So there can be an issue there if you're not e-filing them. Let's see. Actually, I don't do a notice of filing, I do a notice of lodging. And the one that I did do went through right away. And I'll talk more about how that was signed under Rule 14 here after this section. But anyways, it does have to be filed under the same case number. Okay. Both parties have to agree to terminate the legal separation and to restore their status to legally married. And that does have to have the language of the Rule 69 where they are doing it intelligently, voluntarily, without duress, coercion, or undue influence. Upon the entry of the stipulated order, the marital community is reformed as of the date of the termination order. And the legal separation no longer exists. So it doesn't like get erased and it goes away. There's still what happened in between from the legal separation to the time of terminating it. This part of it, these parts regarding property and debt and creditors, I think is the reason the statute was really needed. So any property that's awarded to either party as their sole and separate, and the same for debt, remains that way. That doesn't change. And then any payments due from one party to the other for like spousal maintenance or child support, that is deemed waived. The terms of the legal separation are deemed waived unless the parties specifically state something different in the stipulation to terminate, and the order as well. For legal separations with children, the parenting order